Your Lordship, may I seek indulgence in with respect to item number 9?
What happened?
Yes,
Hearing.
yes. Let the matter maybe take it up in the next available bench for hearing.
Okay, we'll adjourn. This bench is sitting only today anyways. But Mr. LLP and Fellow Chongfu, learned counsel for the appellant, who has prayed for adjournment of the matter, which is not objected by the counsels for the opposite parties. In view of the above, list after 2 weeks.
Next available bench.
Next available bench would be after 2 weeks. Any
Yes.
available bench after 2 weeks.
Yes, oblige, Your Lordship.
Motion, item 1.
Lordship, I am here to submit the additional affidavit. It is at the verge of completion, so we will be filing next
Further
week.
time.
Yes, Lordship. The representation which I have sent on 10 February this year, they have made a reply on 19 June. So there are some translation which needed to be done, so that takes a little bit time, Lordship.
Okay, Ms. Rosalind Elma, learned counsel for the petitioner, has prayed for, how long will you take?
We will be filing next week, Lordship.
2 weeks' time?
Yeah.
In compliance with this court's order dated 10/06/2025. Accordingly, list after 2 weeks.
Obliged, Lordship.
Motion, item 2.
My Lord, I am appearing on behalf of my senior, the counsel for respondent 6. We have received the pairwise comment from the commission, and my Lord, I seek 2 weeks time.
Counsel for respondent number 6 has prayed for further time to file their counter affidavit, and and the counsel for the petitioner has also prayed for time to file the rejoinder affidavit to the counter affidavit filed by the state respondents. In view of the above, list after 2 weeks, 3 weeks.
4 weeks, my lord.
Okay, 4 weeks. Meanwhile, the respondent number 6 should have filed their counter affidavit, and the counsel for the petitioner may also file their rejoinder affidavit to the counter affidavit so filed, if so advised. Yes, list after 4 weeks.
Item 3.
First time. Jail appeal?
This is a jail appeal. Grant adjournment regards to item number 7 of the hearing list.
All these mentioned should have been made previously. Anyway, 7, what is the hearing? It's not even here with me now.
Your Lordship, the main counsel is having some personal difficulties and is unable to appear today.
7 of
Yes,
the
Your
hearing
Lordship.
list, part
Yes.
2.
Yes.
So, you can have it any day this week.
My Lordship, if it could be taken up next week.
Okay, 7 order has already been passed. Please find out.
Yes, Your Lordship.
7, part 2.
Yes.
I'm informed that order has already been passed. Is it?
I am not aware of it, Your Lordship. I was made to seek an adjournment.
What? Not passed. Huh. So you wanted some other week?
Next week, Your Lordship.
Next week? Have you taken the consent
Yes, Your Lordship.
of the other side? Mention is made on behalf of Mr. B. Laramena, learned counsel for the appellant, for adjournment of the matter with the consent from the other side. In view of the above, list in the next week.
Oblige.
Addition, item 1.
Now, item number 1, okay, the learned AG is appearing through VC, is it?
My lords, parties are here. My lords.
Yes.
Yeah, my lords, this pertains to challenge to the cancellation of appointment of CEM, and also further challenge to the appointment of CEM. So this is the crux of the case. My lord, before I submit that, the constitutional importance, the questions of law importance is that whether the governor can can terminate the CEM, whether the governor can terminate chief minister, and likewise whether the president can terminate the prime minister. This is very important in the democratic form of government like in India. So in this case, the governor directly terminates CEM because in Autonomous District Council in 6th schedule, CEM is same like chief minister, and in the Indian constitution, the power and function of the governor and the presidents are same. Now, the only difference is that the article number. So in this case, the governor directly terminate the present petitioner. Before I go, I would like to draw your kind attention to a very brief fact. There are only some 5-4 important dates, Your Lordship. So the problem starts from 1st January 2025 on 30th. So here the petitioner, they submitted letter to the governor. So
On 1st January?
on 30th January,
30th. Ah.
301-2025, here 13th elected MDC, they intimated the governor about the failures of the command by the unswell MDC, Executive Council. So there, they requested to convene a meeting. They requested the governor to convene a meeting, emergency meeting, to conduct floor tests. Actually, there is a challenge. There is a They submitted that the present executive councils, they failed to command majority. There are 25 members elected MDC. Here, 13 of them submitted this letter. So they have majority. So this letter was on the basis of sub-rule 2 of Rule 21 of Lai Autonomous District Council, CCB Rules 2010. So that they claimed they submitted because they have command majority, they have majority numbers, that's why. So my lord, and after submission of this letter, so that the respondent number two is Secretary to the Government of Mizoram, District Council and Minority Affairs Department. After receipt of that letter, so respondent number 2 directed to conduct floor test. On 7 February, respondent number 2 informed the respondent number 3 to conduct floor test. On 12 February.
Who is respondent number 3?
Number 3 is the governor, number 4 is LADC. Respondent number 2 directed respondent number 4 to conduct floor test.
Governor, advise the governor.
Yes.
He said,
So, Lordship, on 10 February, respondent number 4 issued notification to conduct floor test on 12 February.
Who is respondent number 4?
Respondent number 4 is LADC. Here the-
No, you said that on 10/2/2025, respondent number 3, is it?
Yes, 3.
Okay, okay.
Respondent number 4, Lordship. Respondent number 4 issued notification for conducting floor test to have emergency meeting on 12 February. So, my lord, very crucial here on what happened on 12 February. Because the Antwerp Executive Council lost majority as they submitted letter on 13, and the Antwerp CEM submitted his resignation before they conduct floor test.
When?
On 10 a.m., 12 February. Kindly note that 12 is the appointed date for conducting floor test. Just before they conduct floor test, since he commanded absolute majority, he submitted his resignation at 10 a.m. So there was no
What?
floor
The
test.
CM.
Yes, CEM. So on the same day,
His floor test. is
yes,
it?
he lost majority, and on 10th he submitted his resignation.
He submitted his resignation when?
On that 12th.
On 12.
Yes,
that's all,
12.
No, on 12. Sometimes you're saying on 10th, that's why.
No, at 10 a.m. What I say, 10
Okay,
a.m. in the
okay.
morning. So on that very same day, on 12, the 13 elected MDC, they stake claim. They stake claim to the governor. So citing that we elected the present petitioner to be our leader, so we have absolute majority. So invite us to conduct floor test on 12. So then, pursuant to that letter, for claiming that on 24th February itself, there is appointment. There is appointment of the present petitioner as CEM.
So what happened on the 12th? Nothing happened.
12, that the government, it was toppled because he lost majority. He submitted his resignation.
Okay, so floor test was there?
Yes. No, actually, floor test was actually not actually conducted.
No floor test was
Yes, since he
conducted.
submitted his resignation.
Okay, since the CM submitted his resignation, no floor test was
Yes, yes.
there. Okay.
So on that very same day, 13 MDC, they stake claimed and they sent letter to the governor for formations of the government, formation of the council on that the same day itself.
Okay.
So on 24th February, this is important, this letter has been cancelled. On 24th February, the respondent number 2 issue notification for appointment of this present petitioner as CEM.
That is you, is it?
Yes, it's me. So, my lord, I would like to take you to this letter because very important. It's coupled to with some direction as per the CAB rules. It is at page number 72.
Wait. So you were appointed as CM.
Yes, on 24th February.
Where's the letter?
72. So just only a very small sentences. Allow me to read, Your Lordship.
Yes.
In exercise of the power conferred by sub-rule 4 of Rule 21 of LADC CCB Rules 2010, the Governor of Mizoram is pleased to appoint Pu Vizir Sangha as an elected MDC from Paithar MDC constituency and elected leader of ZPM Legislative Party of the LADC as Chief Executive Member of LADC with effect from 24/2/2025. The date of approval of the Governor of Mizoram. Number 2, further as provided under sub-rule 5 of Rule 21 of the LADC rules, the Governor of Mizoram direct the Chief Executive Member to secure a vote of confidence within 30 days from the date of the appointment. I just quickly, before I'll continue again, Lordship. So here, after appointment of the present petitioner as CEM, what he has to do is that he was directed to conduct floor test within 30 days. So then step was taken, and my lord, that respondent number 4 issue notification compliance to the orders of the respondent number 2. So on 4th March, notification of issue for conducting floor test. So the appointed date for that floor test is 18 March. 18 March. So then just before they conduct floor test, he is ready to face the floor test. But unexpectedly on 18 March, the chairman who had to conduct floor test submitted resignation, his resignation on 18 March. He could not conduct floor test as time frame within 30 days. And simultaneously, even deputy chairman also submitted his resignation on the same day itself, on 18 March. So he could not conduct floor test.
Who resigned? The
Chairman,
CEM.
chairman and
Chairman
deputy
is
chairman of
CEM.
LADC.
CEM, that is.
No, LADC.
Chairman.
Chairman and deputy chairman. Chairman is VL Moka and deputy chairman is H. Lalmuan Sanga.
Okay.
Hello, you got my point? On 18-3. 18-3 is the date for conducting floor test. On that, before they conduct floor test, chairman who had to preside over this emergency meeting for conducting floor test resigned. Not only chairman, even also deputy chairman also submitted his resignation. Then floor test could not be conducted. So on that very same day, the present petitioner requested, on the next day requested the governor to appoint pro tem chairman for conducting floor test. He had tried his best to conduct floor test. So on 19 March, just a day after the chairman and deputy chairman submitted their resignation, he requested the governor to appoint pro tem chairman for appointment of chairman. So pursuant to his request, so on 24th March, chairman pro tem chairman was appointed by the respondent number 2, and also notification was issued for appointment of chairman also. So it was to be held on 26 March.
What was to be held on 26 March?
For appointment,
Protest.
for elections of the chairman. On 26 March, chairman was elected. So new chairman was elected. T. Zakunga was elected as chairman of the LADC by uncontested, actually.
Uncontested.
Yes, uncontested. So
So
then
floor test can be conducted?
floor test can be conducted, but
What happened?
without conducting, because their suffering, salaries cannot be cannot be taken before that, because without conducting this one, the floor test, this the new chairman T. Zakunga conducted this one, the budget. There is notification on 2nd April issued by the respondent number 4 for budget session. So then, because what I would like to stress that budget session is that even that the impugned notification which have been challenged in this writ petition under Article 226, we also challenge that the impugned notification wherein even this budget was also cancelled. So budget was conducted, and I have enclosed the budget also, but not all, some of the budget also. It was held on that budget session was held on 17, 16, so and 22 also. So it was passed by majority of the members of the Executive Council. So what is very important here is that there is a direction reminder from respondent number 2. Respondent number 2 is the secretary to conduct. Respondent number 2 sent a letter to conduct floor test to the chairman of LADC on 22nd April. So what is his reply is that because that appointment of the present petitioner was on 24th February 2025, directing that to conduct floor test within 30 days. So counting from the 24th February, 30 days will elapse on 24th March. Because this is what the law says. What is the rule 21.5 of CAB rule says? It should be within 30 days. So it already lapsed on 24th March. So
What is 30 days? Which rule? What?
CAB, Law Autonomous District Council,
Ah.
2010.
Give me a copy.
I think. I have PDF copy in my.
You all have it, but you're not giving the court to have a look. Then how can we?
21.5.
What 21.5?
Rule 21.5.
Executive committee.
Yes.
Ah.
My lord, if you kindly see that notification for appointment of the petitioner, these two rules, 21.4 and 21.5 has been quoted. Because he has been appointed under 21.4.
Where's the appointment letter?
Appointment is at
Page 72.
72.
Yes.
Kindly look back.
21.4.
Yes, 21.4 is the provision for appointment. 21.5 is the date for conducting floor test.
Okay, within 3 months.
Yes.
Within 30
Within
days.
30 days.
Within 30 days, huh?
This
So
is-
within 30 days,
Yes.
it did not happen.
Not happened.
Oh.
Because that on 18 March, that the chairman and deputy chairman resigned. Because chairman is the one who had to conduct floor test. I'm not the one.
So after the lapse of 30 days, what happens then?
And reminder was sent to the newly appointed chairman.
Then?
And then he replied, then stating that it's already lapsed. So requesting a fresh order from respondent number 2. So, my lord, this one is 21A, is the reply by that the chairman, newly elected chairman, so that though
Where's the letter showing that requesting a fresh date, fresh order?
page number 112A,
112A.
112A.
Page.
Yes, page number 112A. Annex 21A. So, my lord, allow me to read a last two para. They are crucial. On account of the above sections,
112 is a reminder, isn't it?
reminder is 112. Because even when reminder was sent, 30 days was already elapsed. My lord, kindly note that. Because a reminder was sent on 22nd April, so that 30 days was already elapsed. Because it already lapsed on 24th March. It was lapsed by 28 days. And on 112A is the reply to the reminder. So that the gist of this reminder is that I could not conduct the floor test because deputy chairman and chairman
Waiting
resigned.
for a fresh order.
Yes.
Okay,
And here, allow me to read last two para, Your Lordship.
yes.
Last two para, on account of the above facts and circumstances mentioned in the proceeding, para, the floor test to secure a vote of confidence is not necessary as provided under sub-rule 521 of LADC Rules 2010. CEM is to secure a vote of confidence within 30 days if the governor consider it necessary to do so. However, direction to conduct the floor test secure vote of confidence is not intimated, and a reminder directing the chairman of LADC to hold a vote of confidence conveyed under such and such was received after conclusions of the budget session held on 17 to 22 April. Lastly, during intervening period of time, 30 days is already elapsed to summon the session to conduct the floor test. Besides, it is also felt extremely necessary that floor test be conducted. Moreover, I am waiting for fresh order for conducting the floor test as provided under sub-rule 5 of Rule 21 of LADC Rules 2010. So, my lord, here what I would like to say is that it is not that the present petitioner as CEM refused to conduct floor test, because it has to start from the chairman. The chairman is, it has to start from respondent number 4, LADC. They have to issue notification, and it has to be presided over by the chairman. So then, after that, on 2nd May, this is in due notification. The notification is issued while the actual CEM, the present petitioner, was still CEM of LADC. New notification for appointment of the another CEM was published on this 2nd May. How can it be possible? My appointment was not at all cancelled.
Where is the notification?
On 2nd, that on 113. So then the present respondent number 5 has been appointed as CEM, the new CEM. Well, the appointment of the petitioner still subsisted at this particular time.
Let's see the order. Read the order.
Yes, 113. In excess of the power conferred by sub-rule 4 of Rule 21 of LADC CCB Rules 2010, the governor of Mizoram pleased to appoint Pu N. Zangura, elected MDC from 21 MCON, Pui MDC constituency, and an elected leader of UPDA, legislative party of LADC, as the CEM of LADC with effect from 30th 4 2025, the date of approval of the governor of Mizoram. Further, as per sub-rule 5 of 21 of LADC, the governor directs Mr. Nzangura to secure a vote of confidence within 10 days of his appointment as CEM.
So same rule number
Same rule.
21-4.
Yeah, because within 30 days is mandatory. Even that the newly appointed CM also has to secure vote of confidence within 30 days, not beyond 30 days.
So you were also appointed under 21.
Yes, because the rules revolves around 21, 4 and 5. This is the only rules for appointment of CEM.
So I think, okay, anyway, so in after lapse of 30 days, he's no longer, maybe that's a stand. Anyway, let's see.
Yes, yes, Lordship. So subsequently on 7 May, thinking that his mistake might be, so again, he issued notification, respondent number 2 issued notification for cancellations of the appointment of the present petitioner, who was appointed as CM on 24th February 2025. How can it be possible? And besides that, the budget for 2025 to 2026, which was passed by in their house by majority was also cancelled by this impugn notification 7 May
Where's that? Page?
115.
Read the impugned notification. Page 115.
115. May I read?
Yes.
In pursuance of the governor direction such and such, the appointment of Pu Vizir Sang CEM LADC White notification dated 24th February 2025 is hereby declared null and void. Consequently, budget for the year 2025 to 2026 presented by Pu Vizir Sanga and passed by the House is also declared null and void. So this has been challenged. So my lord, then on floor test was direction was given and floor test step was been taken. So then we have filed this present petition and also we pray for operations of stay of the notification for conducting floor tests. So my lord, this is my case.
Notification for conducting.
112 at the last annexes 29.
112. This is 22nd.
So this
February.
floor test was to be conducted on 16 May, February 2025. This has been stayed by this honorable
Wait,
court
112. Where's this thing?
29. 122 annexes
122.
29. Last, very
Say
last one.
112. So 122. So where's the
So my lord, here my submission.
16th May.
Yeah, 16 May. It's already lapsed also this one also. Because this honorable court on the very first day when at motion stage this order has been stayed. So my lord, my
So now
submission.
you're still the CEM, is it?
Yes, actually, we cannot say who is the CM. That is the query raised by by the court at the motion stage also.
Oh,
Because
yes,
if you
because your appointment also cancelled
cancel, but
and someone else is appointed, his appointment is now being challenged.
yes,
So they are without a CEM, it appears. Who's sitting in that
actually,
chamber?
my lord, that respondent number 4 acted as a CM, but
Okay.
he has no power. He doesn't do anything
Okay, so
because
the
floor
deputy-
test was not conducted also.
Additional DC.
Not yet, but
So someone is taking charge now.
he
DC
acted as CM, your lordship.
Acting.
Respondent number 5 is sitting as the CM.
Okay, respondent number 5, the time being.
Hmm.
Okay. Who is respondent now? The deputy commissioner, most probably.
No, there was no power assigned to deputy commissioner. My lord, first, like that regarding that issue, I would like to take you to para 10 of the very first order passed by this honorable court on 15/5/2025. 15/5/2025. You're there? Para 10. Here is the order passed on the very first day. Allow me to read. That is the gist of the case. It is very clear here, Your Lordship. From para 2, Learned Council submits that petitioner who is elected MDC from Paithar constituency and also elected leader of the PM leader party of the LADC was appointed as CEM with effect from 24th February 2025. The said appointment was made in terms of Rule 21(4) and 4 of LADC CCB Rules 2010. By the same notification, it was provided that the petitioner should secure a vote of confidence within 30 days from the date of his appointment as Rule 21(5). Following his appointment, a session was summoned by the chairman on 18/3/2025 at 10:30 to have the floor test by notification dated. However, session could not be held since the chairman as well as deputy chairman had submitted their resignation. Consequently, a pro tem chairman was appointed for the purpose of chairing the proceeding to appoint the new chairman, and accordingly, one T. Zakunga was elected as chairman. The new chairman, via notification dated 2/4/2025, in exercise of the power conferred upon him by Rule 32(4) of CCB rules, summoned 11 Lai Autonomous District Council to sit for an emergency session commencing from 4/7/2025 at 10:30 a.m. It was notified no other business except discussion on LADCP budget for the year 2025 to 2026, and the elections of deputy chairman will be taken up. The budget session was accordingly held, and at the same
There's a
time,
mistake with the date here, isn't it? Para 3?
I think this is mistake.
It should be 4. It cannot be 7.
Yes, it's mistake. Typo mistake.
It should be 4, isn't it?
Yes.
I'll just make a pencil correction because it can.
On para 4, after budget session was over, chairman of LADC communicated dated 28/4 wrote to the governor of Mizoram to secretary to the government of Mizoram DC
So
and
when the emergency session was called on 04/04/2025,
first it was called by notification dated 24th February.
so here it says to sit for emergency session commencing from 04/04/2025, para 3.
Yes.
So
Actually,
when this emergency session sat, why wasn't a floor test conducted then?
my lord, because that not his appointment was 24th February, counting 30 days from 24th February,
Okay, so they felt that there was no
it was
urgency.
lapsed. Yes.
No. No, I'm just trying to get the facts right. 24, so 24/02/2025. So 30 days will be 24/03,
Yes.
2025. Okay.
Yes.
And the,
In fact, he requests fresh order from from respondent number 2. So, my lord, para 4, allow me to read para 4.
yes, yes. please.
After budget session was over, chairman of LADC wrote to the governor of Mizoram, to secretary to the government of Mizoram, DC and MA, informing that since the period of 30 days for having floor test had already lapsed, a fresh order for conducting the floor test be issued in terms of rule number 21(5) of CCB rules. However, instead of giving further time to have floor test on the appointment of the petitioner as CM, respondent number 5 was appointed as the new CM via notification dated 2/5/2025 by the governor in exercise of the power conferred by Rule 21(4). Further, respondent number 5 was directed to secure vote of confidence within 10 days from of his appointment as CM in terms of 21(5) of CCB rules. Subsequent thereto, the appointment of the petitioner as CM, LADC, issued notification dated 24/2/2025 was declared null and void via notification 7/5/2025. Further, budget for the year.
The facts which you have already explained, is
My lord, this is very brief and short, and my short
the
submission
facts
is
which you have already pointed out.
yes,
All this you have, I think, mentioned.
yes, my lord,
Your submission,
yes, my submission, and also my lord, here the order of the court. Allow me to read
yes,
at
yes, yes.
10 is the order because here counsels for the respondents were all present. In fact, on the very first day, query was made to the counsel for the respondent that is there any law or rules for termination of CEM under CAB or any in the constitution, and it was answered replied that no, because there is no rules and law for cancellation of the appointment of CM rule at all under CCAB or in the Indian constitution also. And number 10, this is the order of this court. Having regard to the fact that floor test in respect of respondent number 5 is scheduled to be held on 16/5/2025, and at the same time, this is very important, considering the fact that respondent number 5 was appointed on 2/5/2025, on which date the appointment of the petitioner subsisted as the CEM, because it was still subsisting when the second CM was appointed. It is hereby directed that until the next returnable date, the impugned notification dated such and such shall remain stay. So, my lord, here very crucial point is that how can at a constitutional post,
Okay, now in the rules, you have to study
Yes.
the rules. What happens if the floor test is not conducted within 30 days? Anything?
my lord, it
Anything
is not
mentioned in the
silent.
rules? Nothing.
Nothing.
silent. Because
Because
it appears that the appointment was for 30 days within which floor test should be conducted.
yes,
Now, what happens if after the 30 days lapse, floor
Then-
test is not conducted?
Because-
Anything in the rules mentioned?
no, it's not written there.
Okay.
Then request was made to the governor to issue fresh order. So for conducting floor test.
Okay.
So, my lord, here my first point is that the governor cannot directly
Yes.
cancel the appointment of the chief minister, even also CM also in democratic country. Likewise, the president cannot terminate the appointment of the prime minister. This is the very whole crux of this case. Because there is no law at all. There is no rules at all.
So what you should have two chairs.
Yes.
Two CMs should
Yes.
CM
Yes.
should sit.
At least he has to issue terminations, my termination first. After that, the new appointment has to be made. My lord, actually, very interesting thing. The similar case has been faced in Meghalaya, in Shillong,
Okay.
like exactly like this. But here in this case, at motion stage, so because since there is already chairman, the second chairman cannot be appointed in this case, and there is the observation.
Also court.
It's Shillong.
decision of the court, huh?
Very, because this is in respect of very same issue, Sikh schedule, and CM also. Very short one.
So the matter is not the same, disposed yet.
Actually, that is what interesting is that because in the oral observation, the court pointed out that irregularity and all something like that. But in the next, I have furnished also the next order also. They cancelled the notification in Meghalaya. Because there cannot be two CM at all.
No, the Meghalaya, governor of Meghalaya cancelled
Yes.
the impugned notification.
Yes.
And because of that, the nothing.
Petition
survives
became
the
rendered
petition,
infructuous.
huh.
Yes. But it's very clear from the first order. So, my lord, here my point is that, one is that,
What is very clear from the first order?
no, first order is that if you see this in respect of the challenge to the appointment of the CEM to conduct the floor test.
So what is the observation of the court?
Because the observation, because it
Somebody
was
says I
they
did
rendered
not hear
infructuous. Because since they cancelled notification which was challenged.
That's in the second thing, but in the first, just the facts are given
Yes.
and nothing.
Yes.
Similar.
Yes.
To the order passed by the bench of this court, huh? Then
Yes. So here my point is that the CEM can be, or the governor can exercise his discretionary power only on the advice of the councils of ministers. Here, no advice has been shown, and there is no such things at all. So I would like to rely upon Milai Richa. We have furnished.
what is the citation?
Milai Richa is 2005 volume 2 SCC 92.
Hmm.
2005 volume 2 Just before I go to the relevant point, very brief fact is that in this respect, this is Mara Autonomous District Council, wherein the issue is that appointment and terminations of nominated and elected member. Here, it has go up till DB and again to Supreme Court, because the governor enjoy discretionary. This is in respect. The issue is that regarding discretionary power of the governor. So the case was dismissed, but here the Supreme Court took it. This is very serious case. First, it was laid before 3 judges bench. Again, since it revolves around the discretionary power of the 6th schedule in Mizoram, so it was again laid before 5 judges bench. So I would like to take you to paragraph 5. This is what I have submitted. When the matter came up for consideration before a bench of 2 judges on 27/1/2003, the following order was passed. Leave granted. The issue which has been raised in this appeal relates to interpretation of para 2(1) sub-rule 6A of para read with para 20BB of the 6th schedule to the Constitution. The dispute centers around the natures of discretion to be exercised by the governor in nominating and removing the person to the district councils of Mizoram. We are of the view that the issue raises substantial questions of law as to the interpretation of the Constitution provision having repercussion throughout the state of Mizoram in terms of Article 145 Clause 3. The matter must be placed before Chief Justice. Application for interim relief is also referred along with the main appeal. And para 6. The matter came up before a bench of 3 judges. After 3 and 3, this is the decision. On 28/7/2004, the bench observed in view of the order dated 27/1/2003, the matter needs to be heard by Constitution bench. Thus, the matter came up before the Constitution bench, 5 judges bench. So this is regarding discretionary power of the governor. So para 12. There are several powers and duties for the governor, and some of these powers are to be exercised in his discretion, and some other powers are to be exercised by him with an advice of the councils of ministers. Executive powers of the state are vested in the governor under Article 154(1). Article 163(1) states that there shall be a councils of ministers with the chief minister as the head to aid and advise the governor in exercise of his function, except insofar as he is by under this constitution required to exercise his functions or any of them in his discretion. I'll skip in paragraph 14. Our constitution envisages the parliamentary or cabinet systems of government of the British model, both for the union and the states. Under the cabinet systems of government as embodied in our constitution, the governor is the constitutional or formal head of the state. He exercises all his powers and functions conferred on him by under the Constitution on the aid and advice of the councils of ministers, save in sphere where the governor is required to, by under the Constitution, to exercise his functions in his discretion. Executive power also partakes the legislative or certain judicial action, whenever the Constitution requires the satisfactions of the governor for the exercise of any power or function. Satisfaction requires by the Constitution is not personal satisfaction of the governor, but satisfaction in the constitutional sense under the cabinet systems of government. So the governor exercises functions conferred on him by or under the Constitution with the aid and advice of the councils of ministers, as he is competent to make rules for convenience transaction of the business of the government of the state by allocating of the business among the minister under Article 166 of the Constitution. So I'll go to para 18. The scope and ambit of the power of the governor came up for consideration before 7 judges bench in Shamsher Singh and state of Punjab. The 2 appellants were the members of the subordinate. This is the case, but I would like to go to which was cited in this case at para 28. Under cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his councils of ministers, save in
Wait, you're reading from where, para?
no, this same para in 18, in this
Para
judgment,
18.
para 28 was,
Okay, para
yes.
18.
Yeah, para 18, in this judgment,
Yes.
another case was cited
Oh,
under the cabinet systems of government. In our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and function conferred on him by or under the constitution on the aid and advice of his councils of ministers, save in spares when the governor is required by or under the constitution to exercise his function in his discretion. In the instant case, the member held office during the pleasures of the governor, councils of ministers advised the governor to terminate member of this appellant, and all relevant records were placed before the governor. The relevant paper shows that the content of all relevant files were brought to the knowledge of the governor, and he accepted the advice of his councils of ministers. As the governor was not left with any discretionary power, he was bound by advice given by the councils of ministers. So this case, what it has postulated, the principle laid down is that the discretionary power has in respect of in that autonomous district council in 6th schedule in the state of Mizoram, he has to act in the advice of the councils of ministers. So this is what it's laid down in this provision, 5 judges bench. So in respect of our case, there was no consultation or there was no advice. So I would like to submit one, because recently in Chakma Autonomous District Council, so the governor had sought the advice of the councils of ministers. So may I please furnish this one? My lord, what my point is that I'll just tell you, I'll just inform the court very frankly that the governor was appointed by BJP, and then he's a so then now the present that side, let me just say that which he's going to appoint, to give power, is the BJP side. But in respect of this Chakma Autonomous District Council side, so and now that the BJP government was toppled down, so new government was going to be formed, but he refused to invite. But in this case, the governor was very hurried to invite the Fortes, but in Chakma Autonomous District Council, they have 16 members out of 19 elected MDC. They have a very absolute majority. Instead of inviting them, he straight away passed this order. But in this respect, when he exercised his discretionary power, he sought the advice of the councils of ministers. But not in this present case, in LADC case. If you kindly see Parachi,
yes.
it is very clear, yes. Here,
Council of Ministers.
yes. So, my lord, one thing is that very landmark case, well-known case, Nabam Rabia, 2016, volume 8, SCC. Yes.
Page 8 SCC,
My lord.
what?
Nabam Rabia, 2016, volume 8, SCC 1. Before I submit further, very brief fact here, the discretionary power of the governor has been examined by the Supreme Court, whether he has to seek advice of the councils of ministers or not. Because here, in this case, what was held by the Supreme Court is that the governor, while exercising his discretionary power, has to seek the aid and advice of the councils of the minister. This has been highlighted. I would like to read the relevant portion, Your Lordship. Actually, it starts from 145. Important issue is very lengthy judgment, but may I read, please?
Yes.
145. Even though the position expressed in the preceding paragraph is clear and explicit, yet the learned counsel representing the respondent at his own acceded to one exception to the proposition canvassed by him, namely that a determination at the hands of the governor in his own discretion would be subject to judicial review when it can be shown that the discretion exercised by the governor was not bona fide or not on due consideration. It was illustratively submitted that the governor exercise of discretion would be open to challenge when it can be shown to be perverse and capricious or fallacious, extraneous, or for a motivated consideration, or in situation of the like nature. Stated simply, it is considered that an order passed by the governor in exercise of his own discretion without any aid or advice can be successfully assailed if it can be shown that in discretion exercised by the governor he had acted wantonly, whimsically, and arbitrarily. Therefore, said submission of the hands of the land councils for the respondent, though extremely attractive, seemingly emerging from a plain reading of Article 160, Clause 2, cannot be accepted. The reason for our determination are being narrated in the following paragraph. First of all, it is extremely essential to understand the nature of the power and functions of the governor under the provisions of the Constitution, insofar as the instant aspect of the matter is concerned. It is apparent that the governor has been assigned functions and power concerning executive and legislative affairs of the state. The executive function of the state, I'll just go that these are relevant to the concluding part. Here from 153. These are all in between para, also relevant for me, are in my favor. Though debate could be endless, yet we would consider it opposed to avert to the decision rendered by this court in Sardar Lal case and Shamsher case. Insofar as Sardar Lal case is concerned, this court had held therein that the president of the governor, as the case may be, would pass an order only on his personal satisfaction. In the above case, this court, while examining the case of an employee under 3112, recorded its conclusion in manner expressed above. The same issue was placed before a 7-judge bench to re-examine the position adopted in Sardar Lal case. Because Sardar Lal, before that, he can enjoy his discretion as his personal satisfaction. It was examined. The position came to reverse. It became reverse. This court in Shamsher declared that whenever the Constitution requires satisfactions of the president or the governor for exercise of any power or function, as for example under Article 120, 123, 213, such and such, satisfaction required by the Constitution was not personal satisfactions of the president or the governor, but is the satisfactions of the president or of the governor in constitutional sense under the cabinet systems of government. It is therefore clear that though the governor may be authorized to exercise some function under different provisions of the Constitution, the same are required to be exercised only on the basis of the aid and advice tendered to him under 163, unless the governor has been expressly authorized by or under the constitutional provision to discharge the function concerned in his own discretion. 160 is very simple, that one. This is the power of councils of minister. If you want me to read, I have it.
No need.
153.
No need.
No, 155. We therefore summarize our conclusion as under. Firstly, measure of discretionary power of the governor is limited to the scope postulated, therefore under 163A. Secondly, Article 163A, discretionary power of the governor extends to a situation wherein the constitutional provision expressly requires his governor to act his own discretion. Thirdly, the governor can additionally discharge function in his own discretion where such intent emerges from a legitimate interpretation of the provision concerned. The same cannot be constituted otherwise. Fourthly, in situation where this court has directed that the governor should exercise the particular function of his own without any aid and advice, because impossibility of the other alternative by reasons of the conflict of interest. Fifthly, submission advance on behalf of the respondent that exercise of discretion under 163(2) is final and beyond the scope of judicial review cannot be accepted. So in this case, that the governor acted without an advice of the Council of Ministers, then his order for cancellations of the speaker was cancelled by the Supreme Court. Likewise in our case. So, my lord, as I submitted here, the governor has no power at all to terminate the appointment of CEM in view of CAB rules. The only rules where CEM can vacate his office is that I would like to take you to see that CCB rules 2010. Only under rule 23.
Yes. what
Yes,
is-
CEM can be removed under only 23.
If he submits his resignation,
Yes. 23A. A member holding as CEM or member of executive committee shall vacate his office if he ceases to be a member of the district council, subject to the provision to sub-rule 2. Number that B, may at any time by writing under his hand submit his resignation. In such member is the chief executive member to the governor through the chairman, who shall forward such resignation within 48 hours from the time of receipt of the same. And if member is a member of executive committee, to the chief executive member, who shall forward with recommendation, if any such resignation to the government within 48 hours. On his resignation being accepted by the governor, the chief CEM, as the case may be, such executive member shall be deemed to have vacated the office as such. So he can be removed, or he can cease to be CM only by under 23A. And again is that 83. He can be removed, or executive committee can be dissolved by only under 83. See, motion of no confidence, because as we are aware that on 21/5, that mandatory period or 30 days became lapse, with no fault on his part of the CM, because he tried his best to conduct floor tests, but it is the another person, chairman, and that the respondent number 3, who has to issue notification. They failed to do so he could not conduct floor tests, because the chairman said that it became lapse. And the another option is that 83A. This 83 has to be read together with 83, rule number 24. Allow me to read first rule number 24. Here, the heading itself is very clear. Removal of members of executive committee. 24A, executive committee shall be collectively responsible to the 24.
so you're reading now which one?
24,
24.
CCB rules.
Yes.
24, 1.
Yes, removal of, yes.
Yes, removal of members of executive committee.
Yes, please read.
Executive committee shall be collectively responsible to the district councils and may be removed on a vote of no confidence passed by majority of the members of district council present at a meeting specially convened for the purpose under Rule 83. Because bypassing those notifications automatically remove all the executive members. And 83, as I
Yes.
have taken to you. Yeah, 83 is motion of no confidence in executive committee. This is the manner how the unswell party, if they feel that they lost majority, this is the manner how it has to be taken down, toppled down. 83A, allow me to read, Lordship. A motion expressing want of confidence in executive committee or a motion disapproving the policy of executive committee in regard to any particular manner may be made with the consent of the chairman and subject to the restriction that the member making motion shall present to the secretary a written notice of the motion before commencement of the sittings of the day. If the chairman is of the opinion that the motion is in order, he shall read the motion to the councils and shall request those members who are in favor leave being granted to rise in their places, and if not less than 1/4 of the member present rise accordingly, the chairman shall intimate that the leave is granted and that the motion will be taken on such day, not being more than 2 days, not less than 24 hours from the time at which leave is asked for, as may appoint, provided that is exigencies of the business require, the chairman shall have the power to relax the rules and take up the motion earlier than 24 hours. If less than 1/4 of the members rise, the chairman shall inform members that he has not the leave of the councils. This is the manner why how notice of motion has to be conducted. In this manner, the actual executive committee can be taken down by 24, read with 83. This is removal of that. The section itself is very clear. Removal of the executive committee. Again here, motions of no confidence in executive committee. Bypassing all these things, superseding all these things, directly the governor issued notification 2/5/2025 and 7/5/2025, wherein it was never mentioned that he exercised his discretionary power. At least if he said so, we can somehow, they might have some points, but it was silent, that it's simply that issue notification. So again, that notification even also cancel this budget also, which was passed majority in the executive committee. Lordship, if you see 50 and 51, CCB rules, I'll take you to 50 and 50 and 51, because here the notification automatically cancel the budget which has been passed. So here, allow me to read 50,
Yes.
Rule 50. No proceedings of the district council shall be deemed to be or ever to have been invalid by reasons of any rules not being or not having been complied with. But in case any such non-compliance, any member may raise a point of order. So there is no such thing at all. There is no point of order which has been raised. See 51, any member may at any time submit a point of order for decisions of the chairman, but in doing so shall confine himself to stating the point. The chairman shall decide all points of order which may arise, and in his decision shall be final. So how can the respondent number 2 declare that the proceeding, that is the budget proceeding, be declared null and void? That is not on the basis of any rules, any law. Well, the law very specifically said so. In that respect, I would like to rely upon one judgment. Things which has to be done in that particular manner only. Time and again, in a cantina of judgment by this court and Supreme Court also refer. So, my lord, Chandra,
Citation?
yeah, 199, volume 8, 266.
(266).
Yes. Para 17. That the last two sentences start from, it is a salutary principle that if a statute provides for a thing to be done in a particular manner, then it has to be done in that manner and in no manner at all. So this has been originated from this and this judgment, because time and again Supreme Court refer in many judgment. So again, in municipal corporation versus Abilas Lal, 2020, volume 13, 234.
2020, volume 13.
Yes,
SCC
234.
Para?
Para 39. Allow me to read. The principle that if a statute requires a thing to be done in a particular manner, it should be done in that manner or not at all. Article Danzir such and such has found widespread acceptance. In the context of this also the same principle has been highlighted, and I have also the very recent one, (2021) volume 6, 707, Opto versus Axis Bank.
Same principle.
Yes, same principle that has been, yes, principle. So this is my point, is that just to go back on this point that the governor cannot cancel the appointment of the CM, also the chief minister. Likewise, the president cannot cancel the appointment of the prime minister in democratic forms of government. But if things has to be done, because the law is not silent, there is the law how that the CM has been ceased to be CM, and also how notice of motion has to be conducted under 21.5, also 24 and 83 also. And besides also the budget session, rules 51 and 50 very clearly that point of order has to be raised by any member. But here there is no such
So I
thing.
think you're repeating.
Yes, my lord, just my first point, I'll come to the next point. So this is the thing. So my lord, just because here the practice they have, I just want to take you to my petition at ground portion. Here I have made tabular form in table at page number 50 of my petition. of my petition on grounds portion. So, my lord, in the history of LADC, since 1988, what my submission is, since 1998, it never happened like this, because many times we know that we are aware that in LADC, sometimes, it happens sometimes because anti-defection is not applicable, because order passed by this honorable court. Sometimes they change the government, it happens many times. But in that situation also, since 1983, it never happened that the governor directly invite another party who claims that we have a majority before cancellations of the unswell CEM since 1983. More particularly in this 11 LADC. So far there have been 4 CEM in this 11 LADC. The first one is that Mang Hunachinsa. He became CM 14/12/2020 till 26/8/2021. Next, this present petitioner from 27/8/2021 till 7 March 2024. Against C. Lalmuanthanga from 7/5/2024 to 12/2/2025. And fourthly, the present petitioner from 27 to 2025. In all this case, it's all happened that another party claims that they stake claim that now the present unswell member, they lost the majority. Now we invite for floor test. They had been doing.
Floor test was conducted.
In all this respect, floor test was conducted. They lost in the floor test. They always lost in the floor test.
So in the present case, floor test has
Was not
been
conducted.
yet.
Yes. And at least the governor has to pass order under 21.5.
Yes.
Yes, my
okay.
lord.
Anything else?
Yes, my second point is that how can that the appointment of CM be issued while the appointment of the present or unswell CM was still subsisted? It was observed by this honorable court as we read in the first order, that very clearly that. So that for that I also would like to submit some citation. My Lord, 2022, just very recent one, volume 2, 372. But this is in respect of the service matter, but still the principle of law is very clear that
Parent?
my Lord, here in the head note 24, start at the very last 24, para very 24. Unfortunately, it has so happened that after 2012, on the post of Hindi Steno, the appellants as well as respondent 1, 2, 3 are working, which is not permissible. There cannot be appointment of 2 persons on 1 sanction post. Otherwise, there will be financial burden on the state of the 2 persons on 1 sanction post. This is in respect of service matter. And we can also claim that they are doing the service for the state. But I have also this.
Under the judgment?
Yeah, I have not. My Lord, that it was passed by Madras. We have heard
Okay,
this
Madras
already.
High Court.
Yes. WPC 72.
Yes, it's a,
Yeah, my Lord, actually, that one, my junior have not printed out one copy, that copy for me. But the issue is that where appointment, that there is appointment, this is respect of representative. There is one appointment was already made. If you kindly read.
okay,
So
well, the existing of one
existing
appointment,
was
another
there, and
appointment
another
made.
appointment was made. It was cancelled by Madras High Court. Though it might not be binding, but at least it has persuasive effect. Because the first one is in respect of service matter,
Yes,
but the
then-
second one is in respect of this representation.
Okay, now the next one, this is Guwahati High Court. Another judgment you have given here.
My Lord, and one I would like to submit that they, in their counter affidavit, that my third point is that in their counter affidavit is that the reminder was sent to the chairman. So then reminder extended that period of 30 days. But my submission is that though reminder was sent on 20, it was
It
on
was
20.
beyond the 30 days.
Yes, beyond the 30 days, it was very clear that.
So you want it a fresh?
Yes,
list then?
yes.
Yes.
So how can, because as I submitted that CAM, it has no control for conducting floor test. It is that the respondent number 3 who has to issue notification for that. So I want to conduct floor test. I myself requested the governor on 19 March also that the petitioner requested for floor test so that he wants to conduct floor test also. So I would like to rebut another when they submit, if you can give me time for rebut. Because there are some other things he already submitted the car and all something that your court also will not think it is relevant. Because since another new appointment was already issued, it is constitutionally bound as a
Yes.
lawful citizen. He has
So
to
what
hand
do you
over
want
the
to
car.
submit? So what?
No, that in their counter affidavit that this is their point.
Okay,
That when they say, if you feel that relevant, allow me to rebut also, Your Lordship.
No, so you want to rebut later?
Yes,
Okay.
yes.
What I feel or not, I will not disclose to you all right now. I'm just hearing both the parties.
Yes.
Then what else?
Yeah, that's my first submission, Your Lordship.
Yes. Respondents.
Lordship, I think the AG should make his submission first.
Yes. Respondents. AG,
Three
Learned
matters.
AG.
1 to 3. Lordship, at the outset, I would definitely like to refer to paragraph 10. And again, it would be a bit repetition, but it is necessary, my lord.
Para 10 of?
Para 10 of the order dated 15th of May 2025 of this court.
Okay. This court's order.
It will be a bit repetition, but having regard to the fact that float test in respect of respondent number 5 is scheduled to be held on 16th May 2025. And at the same time, considering the fact that the respondent number 5 was appointed on 2nd of May 2025, on which date the appointment of the petitioner subsisted as CM LADC, it is hereby directed that until the next reasonable date, the impugn notification shall be instated. Now, my lord, the relevant portion is, which I want to point out before your lordship, on which date the appointment of the petitioner subsisted as CM. Now, the question is whether this court finds it appropriate that the appointment of the petitioner really subsisted on that date or not, in view of the fact that he did not prove his majority in the House. That is the question to be decided by this honorable court, my lord. Let us leave other things apart right at the moment. My friend was referring to Rule 83 of the LADC CCB rules. But Rule 83 specifically mentions about the no confidence motion to be moved. Here in this case, my lord, no confidence motion was moved. The fact remains that there was no confidence motion in this particular case. If my lord kindly comes to Rule 21(5), under the provisions of which the petitioner was direct, I'm sorry.
Yes, Rule 21(5).
Under the provisions of which the petitioner was directed to take a float test, to go for a float test, my lord, it clearly says that a vote of confidence in favor of the executive committee within 30 days. The period has been specifically mentioned as 30 days. Now that is why at the outset I submitted, my lord, that whether his appointment subsists
After 30 days.
without taking a float test. If his appointment subsists, then, my lord, his removal is illegal. An appointment of a new CM is obviously illegal. But the question is, when he has not opted for a float test, or when he could not go for a float test under any circumstances, within 30 days, which is mandatory as per the rules, whether his appointment subsisted or not. Because that was the core issue, which was decided by the learned single judge when the matter was taken up at the motion stage and the interim order was passed. That issue has to be decided.
That's why I asked what happens after the 30 days. Is there anything in the rules?
After
Nothing
30
is
days, my
mentioned.
lord.
It's silent.
It's silent. The rule is absolutely silent.
There should be some
The fact
proviso,
remains that
isn't it, here in the rules?
there is another
concerning
rule, my
that?
lord. Rule 83, which my friend was referring to, my learned friend was referring to that particular. But here is a case where a no confidence motion was not moved. There was no confidence motion. And alternatively, it's a question whether the governor had the authority to appoint another MDC as a CEM when the
No confidence motion.
incumbent CEM did not take or did not go for a float test within the mandatory period of 30 days.
Yes.
Now, as far as the settled law is concerned, my lord knows that, my lord is very much aware that in Subhas Desai versus Principal Secretary, Government of Maharashtra, my lord, it's reported in Manupatra, my learned
Yes,
Government
with a copy
advocate.
of the judgment.
Miss Mary will hand over the copy of the judgment, my lord. The relevant portion is para 179. Para 179, my lord.
Let her give a copy of the judgment.
I hope Miss Mary Kyanke is there.
Yes, para
179, my lord. To, shall I proceed?
yes.
To avert a no confidence motion, the incumbent government may not advise the governor to convene a session of the assembly, and the speaker may adjourn the sitting of the house to prevent voting for granting leave to move a motion of no confidence. If the speaker and the government attempts to circumvent a no confidence motion, the governor would be justified in exercising the power under Article 174 without the aid and advice of the Council of Ministers. So, here it is a case, my lord, where the petitioner could not face the confidence motion. Of course, the fact remains that the chairman had resigned, the deputy chairman had resigned, and the situation did not permit him to face the no confidence. I must admit that. I have to admit that because that is a matter of the law. But still, as per the rule, my lord, as per the prevailing rule, the petitioner could not face the house and could not prove his majority inside the floor of the house. And as such, the governor exercised his power to appoint another CEM and direct him to face another floor test. Based on the letter which was submitted by the respondent number 5. Now, whether or not that particular action of the governor is permissible under the relevant rules, that is for your lordship to decide.
Okay. Because
I am very much frank on this particular aspect, my lord, because the rule here is silent. And I cannot say that the rule permits the governor to remove the incumbent CM.
So
But
the rule
simultaneously-
itself is a bit incomplete because there's no mention as to what happens after the expiry
After the
of
30
the
days period
30
has
days. There should be some proviso, something,
Exactly,
isn't it?
That is,
So unless we
that
look
is
at
where-
any judgments, the authorities, we cannot, anyways, yes.
that is where, my lord, that is where, my lord, I leave it to your lordship to decide that whether the action of the governor is as per the provisions of the rule or not. But taking into consideration the entire facts, my lord, the fact remains that the petitioner could not face the house,
So now in
which
the
of course is due to
judgment,
the, which of course is due to the resignation of the chairman and the deputy chairman at that particular time, for which the house could not be convened.
now here in your judgments, which are cited by you, it mentions that the governor is justified in exercising his powers under Article 174 of the Constitution. What is
To
174?
direct the flow test.
Okay,
To direct the flow test.
direct of notice. Okay, fine. Now it's time for lunch. Anything else? Any other submission? We'll continue at 2 if you have anything else. Or have you finished with your submission?
No, my lord, I'll just have, I just take another 5 to 10 minutes because
Okay. Now, okay, you can continue then.
shall I
We'll
continue and
at, huh?
shall I continue and conclude?
We'll continue at 2 because it's 1 now.
My lord. June 2025.
Yes.
Now, my lord, we'll see that in page 8, the notification dated 24th of February 2025, annexure 1, wherein the petitioner was appointed as being the leader of the ZPM legislature party, was appointed as the chief executive member of Lai Autonomous District Council with effect from 24th of February 2025. That is the date of approval of the governor of Mizoram. And further, as provided under rule, under sub rule 5 of rule 21 of the LADC CCB rules 2010, the governor of Mizoram directs the chief executive member to secure a vote of confidence within 30 days. This is the first notification, my lord. Thereafter, my lord, on 2nd of April 2025, if your lordship kindly comes to page 9, addressed to the chairman, 11th Lai Autonomous District Council, vote of confidence, that's the subject matter. In inviting a reference to the above letter, copy enclosed, and as directed by the Honorable Governor, you are reminded to hold a vote of confidence at the earliest. Further, you are also advised not to conduct any executive business of council such as budget, appointments, etc. without seeking vote of confidence. So there was a bar, a specific direction not to pass any budget or appointment without seeking vote of confidence. Thereafter, my lord, page 10. Since the chairman and the deputy chairman resigned, so therefore in exercise of the powers conferred under Rule 30 of the Lai Autonomous District Council CCB rules to 2010, as amended from time to time, the governor of Mizoram is pleased to appoint P.C. Byakthang Sanghi, member of the district council, as pro tem chairman to perform the duties of the chairman of the 11th Lai Autonomous District Council with effect from 24th of March 2025. So the pro tem chairman was appointed, and thereafter the chairman and the deputy chairman was also appointed by the pro tem chairman. And thereafter, my lord, this annexure 4 28th April, a letter from he has stated in the last paragraph, if my lord comes to last paragraph, page 12, lastly, during the intervening period of time, 50 days, is already elapsed to summon the session to conduct the floor test. Besides, it is also felt extremely necessary that the floor test be conducted. Moreover, I am waiting for fresh order for conducting the floor test as provided under Sub-Rule 5 of Rule 21 of the Lai Autonomous District Council, Constitution, Conduct of Business, etc. Rules 2010. So, this is the entire events which led to the present litigation, my lord. Now, my humble submission that if at all the Honorable Court considers that the appointment of the petitioner was continuing, then of course, my lord, the appointment made subsequent thereto is illegal. But if on account of Rule 21(5), that is the rule pertaining to vote of confidence being not conducted in the House, if that has not been conducted and that has been violated, then whether the appointment of the petitioner can be considered to be subsisting, that has to be considered by law.
And there are no authorities on such a situation?
My lord, as of now, I don't find anything
Okay.
in the rules. I must frankly submit that I don't find anything in the rules.
Okay.
It ends in 21(5), that you have to take a vote of confidence within 30 days. But if it is not done, what is the situation thereafter? There is no rules. But that has to be followed as per the principles, as per the democratic norms and principles. That much I can say.
Okay. Yes.
That's all, man. Miss Mary Kyante is there, my lord. If there is any questions, she will assess the Honorable Court.
Okay. Fine.
I can take leave, my lord. I'm obliged.
Your Lordship, after hearing the learned AG, I'm quite convinced that the present situation can be settled. The dispute in respect of the present situation can be settled by way of floor test to be conducted and with the direction of this Honorable Court. But before that, Your Lordship, may I try to make a response to the query that Your Lordship has made as to whether, if the floor test is not conducted within the specified date or time, what happens? I feel that the answer is given by the Apex Court by a 9-judge bench in S.R. Bomai versus Union of India.
Citation?
Citation is 1994 3 SEC 1. 1994 3 SEC 1. Para number 393.
Yes.
Even here, floor test was directed to be conducted by the governor, and the direction was made to the chief minister, who was sitting as the chief minister. But chief minister did not go through the floor test. Here, may I read, Lordship?
Yes.
393. In this connection, it would be appropriate to notice the unanimous report of the Committee of the Governors appointed by the President of India, the 5 governors unanimously recommended that the test of confidence in the ministry should normally be left to a vote in the Assembly, where the governor is satisfied by whatever process or means that the ministry no longer enjoys majority support. He should ask the Chief Minister to face the Assembly and prove his majority within the shortest possible time. If the Chief Minister shirks this primary responsibility and fails to comply, the governor would be in duty bound to initiate steps to form an alternative ministry. A Chief Minister's refusal to test his strength on the floor of the Assembly can well be interpreted as prima facie proof of his no longer enjoying the confidence of the legislature. If then an alternative ministry can be formed, which in the governor's view is able to command a majority in the Assembly, he must dismiss the ministry in power and install the alternative ministry in office. On the other hand, if no such ministry is possible, the governor will be left with no alternative but to make a report to the President under Article 356 to declare, to suspend the government under 356. And similar provision is there under the 6th schedule provision, under 16, para 16, 2 of the 6th schedule to the Constitution. There's a provision for suspension
Yes.
of
Constitution of India.
suspension of the district council. Dissolution 16(1).
Yes.
16(1). The governor may, on the recommendation of commission appointed under paragraph 14 of this schedule by public notification, order the dissolution of a district or a regional council, and direct that a fresh general election shall be held immediately for reconstitution of the council, or be subject to the previous approval of legislature of the state, assume the administration of the area under authority of such council himself, or place the administration of such area under a commission appointed under the said paragraph, or any other body considered suitable by him for a period not exceeding 12 months, provided that when an order under clause A of this paragraph has been made, the governor may take the action referred to in clause B of this paragraph with regard to the administration of the area in question, pending the reconstitution of the council on fresh general election. Provided further that no action shall be taken under clause B of this paragraph without giving district or regional council, as the case may be, an opportunity of placing its views before the legislature of the state. This we are not concerned with. Subclause 2 is relevant for the said purpose. If at any time the governor is satisfied that a situation has arisen in which the administration of an autonomous district or region cannot be carried on in accordance with the provisions of this schedule, he may, by public notification, assume to himself all or any of the functions or powers vested in or exercisable by the district council, or as the case may be, the regional council, and declare that such functions or powers shall be exercisable by such person or authority as he may specify in his behalf for a period not exceeding 6 months, provided that the governor may by further order or orders extend the operation of the initial order by a period not exceeding 6 months on its occasion. Under subclause 2 of this paragraph 16, there's a provision for suspension of the district council and to place the administration in the hand of even the deputy commissioner. This is the last resort if nothing can happen. But in the instant case, we are not in such a situation where suspension of the district council is required. Now, here in the case cited in S.R. Bomai's case, Chief Minister was directed to have a floor test and he refused to comply with the said floor test. Then the governor had formed an alternative government, ministry. Here it says, the Chief Minister's refusal to test his strength on the floor of the Assembly can well be interpreted as prima facie proof of his no longer enjoying the confidence of the legislature. If then an alternative ministry can be formed, which in the governor's view is able to command a majority in the Assembly, he must dismiss the ministry in power and install the alternative ministry in office. So here, the petitioner, having been informed to go through the floor test within a specified time, he did not do it because of one thing or the other. And even when election was held in respect of the post of the chairman and deputy chairman, the agenda for the emergent session, the special session, which was summoned to take place on the 17th of April 2025, it was stated that this special assembly of the House will take up only two agendas, such as
Budget.
budget and election of the deputy chairman. It would have been something else. What is more important than those two things is that they have already had the chairman. Election of deputy chairman was not such a necessity at that point of time. Now, when the chairman was already installed, it is the duty of the council to have the special session or an emergency session to conduct the floor test in respect of the petitioner, which has been avoided by the petitioner himself. The submission that has been made on behalf of the petitioner was that it was not the CEM who had not done it. It was the chairman of the LADC who had not conducted the House or the special session of the House for the purpose of having a floor test. So the blame was put on the chairman. But the chairman, as we all know, the chairman or the speaker of the House is acting on the
Yes.
advice and direction of the leader of the House. Though there is no such in writing, but the democratic practice is that the chairman will have to go in accordance with direction of the CEM. So this is the first thing that Lordship, I'd like to react to the submission of the Learned Counsel for the petitioner. At this stage, Your Lordship, I'd like to take Your Lordship quickly to the facts which I have narrated in my affidavit in opposition.
Filed on
Respondent number 4, respondent number 5.
5
5, yes.
on 23rd June, is it?
Yes, 23rd June. Under para 4, has Your Lordship got it? Para 4 of the affidavit in opposition.
Very long paragraph.
Yes.
Yes.
These are narration of facts which are necessary for proper adjudication of the case. My Lordship, the petitioner as well as the respondent number 5 are elected MDCs in connection with the last general election of the 11th Lai Autonomous District Council, referred to as the LADC, held on 4th December 2020, and its term of office is expiring in the month of November. There is the reason for urgency in this case also. The term of office of the 11th LADC is expiring in the month of November. And as a result, election,
Both of
I mean,
them. Oh.
if election is to be conducted, then the model code of conduct will operate at least 1 month prior to that. So, August, September, only 2 months are left now. Though initially the executive committee of the 11th LADC, comprising 25 elected members, was formed by MNF party having a majority of members, that is 20 elected members, while INC and BJP were having 1 MDC each, and the remaining 3 MDCs were elected from independent candidates. Respondent number 5 is one of the 3 elected independent MDCs. 3. The first formation of Executive Committee of 11th LADC with Sri Manghung Jinja lasted till the month of August 2021, when Sri V. Zirsanga, the writ petitioner, had stepped in as the chief executive member of the said 11th LADC on 6 September 2021. The Executive Committee with the writ petitioners as CEM continued till he had stepped down from the said position on 7/3/2024 before the floor test was conducted. In this connection, it may further be stated that the writ petitioner was found guilty in a corruption case in connection with so-and-so case, which is mentioned here, and he was accordingly convicted and sentenced to undergo imprisonment for a period of 4 years with a fine of rupees 3 lakhs, void judgment and order dated 19/1/2024. However, the writ petitioner, having filed a criminal appeal, that is criminal appeal number 3 of 2024, he was released on bail by this honorable court, void its order dated 31/1/2024. So the writ petitioner is still on bail. And 4, after the petitioner had stepped down from his post as CEM, there was a change in the political scenario as a result of number of MNF MDCs having joined ZPM party. After negotiations among elected MDCs, Sri Silal Muantanga, MDC from INC, was elected to be the leader of the INC and MNF United Legislature Party. Consequently, Sri Lal Muantanga was appointed as CEM, void notification so-and-so. Then, while Lal Muantang was functioning and discharging his duties in his capacity as CEM of the LADC with effect from May 2024, there was yet a political crisis in the LADC as the writ petitioner was giving allegiance to the ZPM party. Consequently, 13 elected MDCs, including writ petitioner, had submitted a joint letter undated addressed to the Honorable Governor of Mizoram informing that Lal Muantanga, CM and leader of the United Legislature Party, had failed to command majority in the House. As a result, as provided under Rule 21, Subclause 2 of LADC CCB rules, the Executive Committee had to be reconstituted. Thereafter, an emergency session of the LADC was summoned for the purpose of conducting floor test to be held on 12/2/2025, void notification dated 10/2/25. On the scheduled date, Lal Muantanga had submitted his resignation on 12/2/2025 as the CM of LADC. 6. Thereafter, the writ petitioner had informed the Governor of Mizoram, void letter number so-and-so, that out of the 25 elected MDCs, 13 of them had formed the ZPM Legislature Party, who had elected the petitioner as their leader. Accordingly, he had staked his claim for being appointed as CM of LADC. Consequently, void notification so-and-so, dated 24/2/2025, writ petitioner as CM of LADC with effect from 24/2/2025, was required to have a floor test to secure a vote of confidence within 30 days as provided under Rule 21, Subclause 5 of 2010 rules. In the meantime, allegedly due to resignation of the chairman and deputy chairman of LADC, writ petitioner did not have any floor test despite direction of the governor of Mizoram. Thereafter, on the election of Sri T. Zakung as chairman of LADC, an emergency session of LADC was summoned for only 1 day for the purpose of discussing budget of LADC for the year. Here, though I said only 1 day, it is for 4 days, Your Lordship.
Okay.
For the year 2025-26 and for election of deputy chairman to be held on 17/4/2025. It may be stated that the writ petitioner who was directed to have a floor test to confirm his having the support of majority of members in the House as provided under Sub-Rule 5 of Rule 21 of 2010 rules as stated in the said notification dated 24/2/2025 had deliberately failed to go through the floor test to secure a vote of confidence in his favor despite direction of the governor. Further, despite the lawful direction of the governor not to conduct any executive business of the council, such as budget, appointments, etc., without seeking vote of confidence, as conveyed, white letters dated so-and-so, 21/4/2025 and 22/4/2025. He had presented the budget for the year 2025, and the same was discussed and passed in the House. 9. During the said emergency session of the House, the writ petitioner did not like to have a floor test as he knew very well that he did not have the support of the majority of members of the House. In fact, while the emergency session for passing of the budget was going on, all the opposition MDCs left the House, and even the respondent number 5 had raised strong objections against discussion passing of the budget. However, the House, without giving any heed to the direction of the governor not to conduct any executive business without seeking vote of confidence, the budget was passed illegally and without authority. In the meantime, yet another change in the political scenario took place in which the lone member of BJP and the MNF MDCs, comprising of 13 members, form a united democratic alliance with the respondent number 5 as its leader. Since the said United Democratic Alliance was in majority in the House with 25 members of elected MDCs, they had made their claim for forming the executive committee of the 11th LADC. Under the given circumstances, the governor of Mizoram was pleased to direct that election of previous CEM, namely Sri V. Zirsanga, be declared as null and void. Budget presented by CEM, ex-CEM, and passed by the House be declared null and void. Appoint a pro tem chairman for swearing in a new CM, V. N. Zangura, newly elected CM, who N. Zangura must prove his majority on the floor of the House within 10 days of his election. No legislative business or administrative decision be taken by LADC with new CM proving his majority. The decision of the governor was conveyed by the Secretary to Governor, white letter dated 2/5/2025, addressed to Secretary of Government of Mizoram, DCNMA. The decision was made by the governor due to the fact that Sri V. Zirsanga, the writ petitioner, did not prove his majority on the floor of the House, despite clear instruction and without proving his majority. He presented the budget of the LADC for the financial year 25-26 in clear violation of direction of the governor and of the parliamentary practice. Consequently, white notification dated 2/5/2025, Governor of Mizoram was pleased to appoint the respondent number 5 as CEM of the 11th LADC with effect from 30/4/2025. That's the date of approval of his appointment by the Governor of Mizoram in exercise of the powers conferred by Sub-Rule 4 of Rule 21 of 2010 rules. The respondent number 5 was also directed to secure a vote of confidence within 10 days of the appointment of his appointment as CEM as provided under Rule 21, Sub-Rule 5 of 2010 rules. And white notification dated 7/5/2025 made in persons of direction of the governor conveyed white so-and-so dated 2/5/2025 and 5/5/2025, appointment of the petitioner as CM LIDC by notification of even number dated 24/2/20 was shown to be declared null and void. Consequently, the budget for the year 25-26 presented by Pu V. Zirsang and passed by the House was also declared null and void. By the same notification, it was further directed that no legislative, business, administrative, or executive decision be taken by LADC without the newly appointed CM, that is, the respondent number 5, proving his majority in the House. And by another notification, in exercise of the powers conferred upon him by Rule 32, Subclause 2 of 2010 rules, and in compliance with the order of the Governor, White Letter so-and-so, the dated 7/5/2025, directing the respondent number 5 to secure a vote of confidence, Sri T. Zakunga, Chairman of LADC, was pleased to summon the 11th LADC to sit for its session on 16/5/2025 at LADC Session Hall, Long Klai. On the same date, on 8/5/2025, respondent number 5 had taken oath as CEM of LADC, being administered by Additional Deputy Commissioner, Long Klai District. Immediately thereafter, the petitioner, having accepted respondent number 5 to be the rightful and validly appointed CEM, he had submitted the 2 official cards of the CEM and handed over the same to the respondent number 5. By filing the connected writ petition, the writ petitioner had challenged the validity or legality of the notification dated 2/5/2025 and 7/5/2025, annexes 22 and 23 to the writ petition. On the grounds stated in the body of the petition, while the petitioner had opted not to challenge the validity or legality of the notification dated 8/5/2025, that is, Annex 29 to the writ petition, by which the chairman of LADC had summoned the 11th LADC to sit for its session on 16/5 at 10 a.m. and at the LADC Session Hall. And that was for the purpose of conducting floor tests by the respondent number 5. And
16/5. Writ
Yes,
petition
16.
was filed on?
writ petition was filed on 14/5/2025, and
Before
stay
16th. Oh.
stay was obtained on 15/5/2025. So, in view of the facts and circumstances under which the petitioner had moved this writ petition, it appears that he was not having any confidence to have a floor test in respect of to prove, to secure the majority or the confidence of the House. So when the respondent number 5 was appointed, he had accepted the appointment of the respondent number 5, and he had even surrendered his official cards and handed over the 2 official cards to the respondent number 5. Now, as the Lordship had earlier observed, it is more like a musical chair in which the petitioner is also still trying to occupy the chair. But as of now, the respondent number 5 is occupying the chair. Now, both the writ petitioner as well as the respondent number 5 were directed to have a floor test to secure the confidence of the House as to whether they have majority control over the House. But since the petitioner was certain that he did not have the majority in the House, he was trying to avoid having the floor test. And now, on appointment of the respondent number 5, and with the direction that he should have a floor test, he is now challenging the appointment of the respondent number 5 and his dismissal. In fact,
Ultimately, a floor test has to be taken.
yes,
Neither of them can avoid that. isn't it? Ultimately, floor test is required.
Yes.
But just one question. Now, when the petitioner was appointed, the situation as to when the petitioner was appointed and then later when the respondent number 5 was also appointed, the situation under which they were appointed, is it the same?
Yes, same.
Because here,
Because they stake, both of them stake their
we have
claims.
the majority.
Yes, having submitted a list of those members in support of their candidature.
So petitioner also says that we have the majority.
Yes,
And
yes,
because of that,
same
the
thing.
governor had appointed them.
Yes.
And within 30 days. Then later, again, respondent number 5 says, I have the majority and therefore, so you should appoint me.
Yes,
So under the
yes.
same situation,
That
both
is
of them
true.
have been
That
appointed.
is true. So, as a result, as submitted by the learned AG, the moot point that needs to be considered is whether the writ petitioner, who was required to prove his majority in the House, before proving his majority in the House, is not supposed to exercise any of the
Budget.
executive power. He was not having the power. But in spite of that, he was exercising a power not vested on him. He was simply in the stage of CEM designate. He was not exercising the power of the CEM. He was CEM designate when he was appointed as such. Before,
Like yourself.
yes,
right
like
now.
myself, I'm also a CM designate. I cannot exercise any executive power, such as passing a bill or any such executive powers. But luckily or unluckily for the other side, I am sitting in the seat of the CM. I am now designated as the chief executive member. So I am the CM designate. Until and unless I prove my majority in the House, though I have made my claim before the governor, and the governor, having accepted my claim, I have made appointments in my favor. So,
Okay, the only difference between the petitioner's appointment and your appointment is that when the petitioner was appointed, the previous CM had resigned.
yes,
But in your case, he's still around, and so
they're
he's
still
challenging.
around, vying for the seat of the CM.
So he's challenging your appointment
Yes.
now. Okay.
And the earlier CM did not challenge the
Nothing,
appointment of
because he had
the writ
resigned
petitioner.
himself anyways,
Yes.
isn't it?
And the law that has been well settled by a catena of the apex court judgments
Give me
that
one.
since the parliament or the legislative assembly or even the LADC or the additional, the district councils, autonomous district councils in the instant case represent the will of the people, the elected bodies, and not the governor. Floor test is the only way under the given circumstances. And that's why even the governor, on making appointment of the respondent number 5 as the CM, he had directed that you have to have the floor test within so and so date. Now, when the matter was scheduled for his floor test, this case came up, and on one pretext or the other, they have obtained a stay. Now, on the basis of that stay, that floor test has not been conducted till date. Now, in this connection, may I take a lordship to 3 judgments, your lordship. One is yes, 2019 10 SCC 809.
Yes,
2019, 10 SCC. May I take your lordship to para 6. Aggrieved, may I read the lordship? Aggrieved by the governor's action in calling upon respondent number 3 to form the government, the petitioners have approached this court under Article 32 of the Constitution. On 23/11/2019 with the following prayers. Part A, pass an appropriate writ or order direction declaring that action or order of the Honorable Governor inviting Sri Devendra Fadnavis to form the government on 23/11/2019 as unconstitutional, arbitrary, illegal, void ab initio, and violative of Article 14 of the Constitution of India, and accordingly was the same. B, pass an appropriate writ or order direction of the Honorable Governor to invite the alliance of Mahavikas Aghadi, comprising of Shiv Sena, Indian National Congress, and Nationalist Congress Party, which has the support of more than 144 MLAs to form the government under the leadership of Sri Uddhav Thackeray. And may I take lordship to para 19? In this context, this court in Union of India versus Harichandra Singh Rawat held as follows. Para 30 of that judgment is quoted. This court, being the sentinel on the qui vive of the Constitution, is under the obligation to see that the democracy prevails and not gets hollowed by individuals. Direction which have been given on the last occasion were singularly for the purpose of strengthening the democratic values and the constitutional norms. The collective trust in the legislature is founded on the bedrock of the constitutional trust. Para 20. In a situation wherein, if the floor test is delayed, there is a possibility of horse trading, it becomes incumbent upon the court to act to protect democratic values. An immediate floor test in such a case might be the most effective mechanism to do so. A similar view was expounded by B.P. Jivan Reddy, Justice, in the celebrated 9-judge bench decision of this court in S.R. Bomai's versus Union of India, wherein he held as follows. This 395 has been quoted. The High Court, in our opinion, erred in holding that the floor test is not obligatory if only one keeps in mind the democratic principles underlying the Constitution and the fact that it is the Legislative Assembly that represents the will of the people and not the governor. The position would be clear beyond any doubt. There could be no question of the governor making an assessment of his own. The loss of confidence of the House was an objective fact which could have been demonstrated one way or the other on the floor of the House. In our opinion, wherever a doubt arises, where the Council of Ministers has lost the confidence of the House, the only way of testing is on the floor of the House. Here the exception is mentioned, except in an extraordinary situation where, because of all pervasive violence, Governor comes to the conclusion and records the same in his report, that for reasons mentioned by him, a free vote is not possible in the House. Such kind of situation will not arise in our case.
Not in the case.
Para 21, Your Lordship. This was also the opinion expressed by the Sarkaria Commission Ras Manar Committee and the unanimous opinion expressed by the Committee of 5 Governors constituted by the President of India. The aforementioned judgment of B.P. Jivan Reddy quoted the observations of the Committee of 5 Governors with approval as below. Para 393 in the judgment which I have read out, S.R. Bomai's case. The 5 governors unanimously recommended that the test of confidence in the ministry should normally be left to a vote in the assembly, where the governor is satisfied by whatever process or means that the ministry no longer enjoys majority support he should ask the Chief Minister to face the Assembly and prove his majority within the shortest possible time. A Chief Minister's refusal to test his strength on the floor of the Assembly can well be interpreted as prima facie proof of his no longer enjoying the confidence of the legislature. And may I take Lordship to para 23? 20, let me continue with para 22. The quoted paragraph 2. The only agenda here, this court nearly 2 decades back in Jagdambika Pal versus Union of India, that is reported in 1999, 9 SCC, page 95, had passed an order after hearing counsel of the petitioner and the caveator, directing that a special session of the UP Assembly will be summoned to convene after 2 days on 26/2/1998 with the following direction. 1. The only agenda in the Assembly would be to have a composite floor test between the contending parties in order to see which out of the 2 contesting claimants of chief ministership has a majority in the House. Now, both of us, the petitioner as well as the respondent number 5, we are contending for the post of chief executive membership. Now, the similar floor test can also be held in the special assembly to be conducted as to be directed by Lordship. The only agenda in the assembly would be to have a composite floor test between the contending parties in order to see which of the 2 contesting claimants of chief ministership has a majority in the House.
So you're saying that this court has the authority?
Yes.
No, but they cannot be fixed by this court. It will have to be the concerned authority.
I'll come to that, Your Lordship. And it is pertinently emphasized that proceeding in assembly shall be totally peaceful and disturbance, if any cause therein, would be viewed seriously. The result of the composite floor test would be announced by the Speaker faithfully and truthfully. The result is expected to be laid before us on so-and-so date, when this bench assembled again. Ancillary direction are that this order shall be treated to be a notice to all the MLAs living apart. The notice of the Governor's Secretariat is supposed to issue. In the interim, no major decision would be taken by the functioning government except attending to routine matters, not much of any consequence. And para 23 is relevant, Your Lordship. 6 years later, in Anil Kumar Jha versus Union of India, that is reported in 2008, 3 SCC 150. Similar directions were passed by this court after recording and taking notice of events that had taken place and a few developments in which were in the offing, as reported in media, to observe and direct as follows. Para 5 has been quoted. Though many a relief has been sought for in the writ petition, as also in the application for grant of ex parte stay, for the present, we are satisfied that a strong prima facie case on the averments made in the petition, duly supported by affidavit, has been made out to issue the following interim directions, and we order accordingly. Number 1, the session of the Jharkhand State Assembly has already been convened for 10/3/2005, on which day the newly elected members of the Legislative Assembly shall be administered oath. We direct session to continue on 11/3/2005, that is next day, and on that day, the vote of confidence to be put to test. 2, the only agenda in the Assembly on 11/3/2005 would be to have a floor test between the contending political alliances in order to see which of the political parties or alliances has a majority in the House, and hence a claim for chief ministership. 3, it is emphasized that the proceedings in the Assembly shall be totally peaceful, and disturbance, if any cause therein, shall be viewed seriously. The result of the floor test would be announced by the pro tem Speaker faithfully and truthfully. Because at this stage, Lordship, there was no Speaker in that House. Only a pro tem speaker was appointed. So this sub-para 5, this order by the court shall constitute notice of the meeting of the assembly for 11/3/2005, and no separate notice would be required. Lordship, even in that case, direction was given by the court for having a special session, and that direction was, the order of the court was taken as a notice of the meeting.
If not, who issues the notice? Respondent number?
No, the governor
Governor
is,
through
yes,
the, who is the secretary?
through the
Secretary,
nodal department is
minor affairs,
yes,
what's that?
minority,
Minority something affairs.
district council and minority affairs.
The secretary, isn't
Uh,
it?
Lordship, even if that is, though that is possible, but by order of this honorable court, it is possible that direction be made and that may be taken as a notice to all the parties. The Lordship can very well fix the date for having the floor test. And may I read on, Lordship? Till 11/3/2005, there shall be no nomination in view of Article 333 of the Constitution, and the floor test shall remain confined to 81 elected members only. We direct the Chief Secretary and Director General of Police, State of Jharkhand, to see that all the elected members of the Legislative Assembly freely, safely, and securely attend the Assembly, and no interference or hindrance is caused by anyone therein. Dr. M. Singh V., Learned Senior Counsel appearing for the State of Jharkhand, through the Chief Secretary and Director General of Police, has very fairly assured the court that even otherwise, it is the duty of the state and its high officials to take care to do so, and the direction made by the court shall be complied with in letters and spirit. The aforesaid directions were interim in nature and were passed on the basis of affirmance made in the petition, duly supported by an affidavit. Writ petitions were directed to be listed on the date of the hearing fixed. Lordship, in this particular case, which I have been reading, it is by way of an interim direction that a date was fixed for having a floor test by the House. And the matter is to be reported back to the Honorable Court. And this is the case in respect of Anil Kumar Jha versus Union of India, 2005, 3 SCC. And Para 24, Lordship, 10 years later, Union of India versus Harishchandra Singh Rawat. Again, an interim order was passed after special leave petition was taken up for hearing, though after concession which was made by Mr. Mukul Rohatgi, the Attorney General for India. Union of India has no objection, and so. The floor test was to commence on so and so. Para 25. In Chandrakant Kavlekar versus Union of India, the challenge raised was to press note and communication from a leader of a party to the governor of the state on the issue relating to whether a particular party had misrepresented the facts. Observing that the sensitive and contentious issue could be resolved by a simple direction requiring holding the floor test at the earliest. This would remove all possible ambiguities and would result in giving democratic process the required credibility. Para 26, only the first sentence. Lastly, we refer to G. Parameswara versus Union of India, wherein identical directions were issued in respect of formation of government in the state of Karnataka to test whether the chief minister so appointed enjoyed the majority support of the House. Now, in all this, Lordship, floor test is the solution. And the manner in which the floor test is to be conducted is also streamlined by direction of the Honorable Court. And it is left to the wisdom of the Honorable Court as to whether, by way of interim order, this matter has to be directed, or by finally disposing the matter, that the direction should be made. And in another case, Your Lordship, 2020 17 SCC,
2020, how much?
2020 17 SCC,
17.
page 1. This is Shivraj Singh Chauhan and others versus Speaker Madhya Pradesh Legislative Assembly and others.
Yes. What does it say?
If I
Para?
take Your Lordship to page 41, para 63.
Yes,
The judgment, may I read, Your Lordship?
yes, yes.
The judgment of BP Jivan Reddy, Justice, also referred to a unanimous report submitted by the Committee of Governors appointed by the President of India, indicating that S.R. Bomai's case, para 393, which we have read. Your Lordship, I'll skip this for the time being. But this is in answer to the fact that when there was no floor test, even in spite of the direction made by the governor, when there's no floor test, the governor was forming the alternative ministry.
Okay.
At page 46, Your Lordship,
Para? Our page numbers should not be the same.
para 77, Your Lordship. May I take a Lordship to para 77? Here,
A table
all the
is
previous
there.
cases have been put together in a tabular manner. It is with a view to obviate illegitimate and unseemly political bargaining in the quest for political power that this court has consistently insisted upon the convening of a trust vote at the earliest date. Some of those decisions are summarized in a tabulated statement for the sake of brevity, which is extracted below. The first case, Jagdambika Pal versus Union of India, which was decided in 1999, reported in 1999, 9 SCC. Dispute over chief ministership and majority in the House in the state of Uttar Pradesh, conduct of the Speaker, UP Legislative Assembly was challenged. Then the court heard the matter on 24/2. This court directed the special session of UP Legislative Assembly be convened for 26/2/1998, and a composite floor test was ordered. So, in a similar case, Anil Kumar Jha, Union of India. These are all important cases in respect of floor tests, in respect of a dispute as to who will form the government in the assembly. And Shiv Sena versus Union of India, which I have just read out. At para 78, below the table, just below the table, Your Lordship, there's para 78.
Yes.
The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. Assertion of accountability is a mirror image of the collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shown a light in the often fluid allegiance of democratically elected representatives. This is a matter for their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time the trust vote is directed. all political parties are equally at risk of losing the support of the elected legislators, just as the legislators are at risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both sides of the dispute congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. So here, let's say, even for me, it will be a risk. Even for the writ petitioner, it will be a risk. Even for any other person who may claim or who may stake his claim for the post of CEM, it will be a risk if a direction is made for having the floor test on a particular date. It is up to the elected members of the MDC to vote in favor of a particular person or a particular party. So we cannot, and the Honorable Court cannot control, and even the governor cannot control. So this is the beauty of the democracy, in fact. At page 55, para 87, let me read 88. The challenge to the communication of the governor must fail for the reason that we have already indicated. After the conclusion of the argument, this court has pronounced its operative direction. The order passed by this court on 19/3/2020 is extracted below. Number 1, submissions extending over 2 days were addressed before the court by learned counsel appearing on behalf of the contesting parties in the 2 writ petitions instituted under Article 32 of the Constitution. We have heard Mr. Dusien Dave, Dr. M. Singhvi, all others, learned solicitors, and the former set of counsel have assailed the communication of the governor to convene a floor test. The latter set of counsel have supported the communication of the governor. Submission which have been urged before the court would necessitate a judgment which would take some time to be delivered. The state of uncertainty in the state of Madhya Pradesh must be effectively resolved by issuing a direction for convening a floor test, bearing in mind the principles which have been enunciated in the decision of the 9-judge bench of this court in S.R. Bomai case, and in the decision of the Constitution bench in the Bam Rebia and Bamang Felix versus Arunachal Pradesh Legislative Assembly. These principles have been consistently reiterated in several subsequent decisions of the court, which would be adverted to in the course of the reasons which will follow. We accordingly issue the following direction. This direction, Lordship, is there.
Yes.
The session of Madhya Pradesh Legislative Assembly.
Seven.
Yes.
So,
7 directions are there. So, in view of this, Lordship, now the best solution and solution in the interest of democracy and for upkeep of the principles of democracy will be to have a floor test. Even the governor cannot decide. That's why he is saying that you have to go to the floor test, even to the respondent number 5, even to the petitioner. But since the petitioner did not go to the floor test, in spite of not having gone through the floor test, he had acted as if he were the de facto CEM. He was only the designate, CM designate. And even I am the CM designate, I cannot do anything important, business cannot be transacted, only as I am now, because that power has not been given to me. Only after floor test. If that is successful, I'll be having the power of the CM, otherwise not. So in view of all this, the challenge as to whether the appointment of the respondent number 5 is during the subsistence of the writ petitioner or not is a very academic question. It's more or less an academic issue. It can be passed over for the time being.
Okay, so,
And-
so without looking to the merits of the case.
Yes,
the merits,
without looking at the merit of the
The
case.
problem can be solved, that is his suggestion,
Yes,
that
even if,
the writ petition can be disposed of by maintaining status quo and ordering for a
floor test.
floor test. But the
date of-
question still remains regarding the budget which was passed.
Yes, the authority, the CEM designate who did not have the power had passed the budget. So it cannot be a budget which was passed by a competent authority. The question as to whether there's a possibility of reverting it or not, that will not arise. Because as and when the CEM is having a power to do that, budget will be passed. And even at this stage, the people are suffering because they have to get their salary, they have to get whatever money from the
So now the
This
budget
district
that was
council-
approved, that has also been stayed or what?
Yes.
But no one can act on it anyways.
It has not been approved.
Oh,
The budget has not been approved. It has been declared to be null and void
okay,
by the governor.
by the governor.
As a result of that, people are suffering now, and the floor test has also been stayed. And since they are in a crisis, and since the appointed CEM, either of the writ petitioner or of the respondent number 5, though they were appointed as such, they have not been having the power. So as a result, for the purpose of quick solution of the problem, if floor test is directed within a week or so, Lordship will be in a position to dispel all such issues and solve the problem of the people, not only between the two contending persons, such as the writ petitioner and the respondent number 5. And so far as the decision which has been rendered by the governor, whether with the aid and advice of the Council of Ministers, that is not a very important question in the instant issue. The Lordship, for the purpose of making of the Lai Autonomous District Council Constitution, Conduct of Business Rules 2010, the provision of law which has been invoked is given in the preamble to the source of the power, the Lordship has been shown. In exercise of the powers conferred by sub-paragraph 7 of paragraph 2 of the 6th schedule to the Constitution of India, read with paragraph 20BB of the said schedule, Lai Autonomous District Council, Constitution, Conduct and Business of Business, etc., Rules 2010, hereinafter referred to as the principal rules, namely so and so. This rule has been made in exercise of the powers, the discretionary power under 20BB. Lordship, if I take Lordship to the constitutional provision, 6th schedule, 2(7). Para 2, subclause 7. This provision of para 7 of para 2 has come under 20BB. 20BB, Lordship, I don't know whether Lordship is looking at the same book, but under 20BB, there's a provision, exercise of discretionary powers by the governor in the discharge of his functions. The governor, in the discharge of his functions under subpara 2, and 3 of para 1, subpara 1 and subpara 7 of para 2. This is the provision of law which has been cited here for the purpose of making these rules.
20 BB.
So this is under the discretionary power of the governor. It is no longer necessary once the rule is made, once the rule is framed and approved and assented to by the governor. Whatever action that may be taken under this provision of law needs no further advice of the Council of Ministers. So the governor, in acting or doing anything under this, is not supposed to take the aid and advice of the Council of Ministers any longer.
No, you just read 20 BB, is it?
Yes, Your Lordship.
But this 20 BB is not here, it's 20B.
At the foot of the page, my lords.
20B is there. 20BB is,
Okay, footnote. Why is it in the footnote? Inserted, okay, later inserted for Mizoram and Tripura and
yes,
Mizoram.
after para 20B.
From
the following-
12/9/1995.
Yes,
Ah,
yes, that is there.
okay.
20BB.
So you're saying that the,
My Lordship, there may be certain things which may be important, which I left unaddressed. Let Mr. Jordan
yes, ah,
address the court with the permission of the Honorable Court.
My lord, actually, I object because normally, and the procedures is that when senior counsels address in assisting counsel never address the court.
My lords, there is no such rule. In
No,
fact, the
no, I have
Supreme Court
never.
has in fact
no.
encouraged junior lawyers to, my lords, make submissions, and I'm doing it
yeah,
with the
there's no harm,
permission, my lords.
Yes, yes.
It is a great privilege to, my lords, assist Puramzawa. In fact, my lords, I do this with his permission. As a junior lawyer, I was hoping my friend would allow me.
Yes, even in the apex court, they assist.
My lords, I would not make my submissions very extensive. Just some pinpoint paragraphs of these judgments, relevant judgments, which my senior has, my lords, referred to. In Shivraj Singh Chauhan, my lords, in this judgment, if, my lords, I have a different printout, but I believe,
This is which citation?
this one. My lords, this is 2020-17 SCC 1.
Ah,
Which
okay,
was
in
just
that
read out.
order,
Second, my lords, out here, I wish to place certain relevant paragraphs. This is, my lords. This is at. Eh, full. Your Lordships, I've given one different publication. This is by Supreme Today. I had sent it to the court
Anyway,
master.
so you tell us the para,
My lords, para 43.
see
This-
43, what is para 43?
My lords, I'll be, if I may be allowed to resend this to the court master.
There's no para 43 or what?
My lords, in the-
2020-17 SCC.
Yes, my
What?
lords. I've sent it to
17.
2017, my lords. 2020, para 7, volume 17.
Volume 17,
Page
SCC
one.
1. They already have it here. You'd already found that here.
My lords, the thing is, I have a different publication, so the paragraph numbers are a bit different. Oh, my lords, it is here only. Yes, yes. It is at para 71 of this publication.
Para 71.
This can be. May I read, my lords?
Wait.
Your lordships has it?
Para 71.
Yes. My lords, if I may read. The powers which are entrusted to constitutional functionaries are not beyond the pale of judicial review. Where the exercise of the discretion by the governor to call a floor test is challenged before the court, it is not immune from judicial review. The court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane to the exercise of the power. I stop here, my lords. Your lordships, even though the petition has not raised this question, it is something your lordships must deal with. But your lordships need not extensively see the whole record. This is coming from, my lords, the counter affidavit filed by the state. There, my lords, this objective decision of the governor has been made on this material, whereby, my lords, I as respondent 5, I have staked claim with the
So
required,
you have the majority.
with the majority.
Same thing he had done, the petitioner,
Correct.
simply has a majority.
But the problem is, my lords, they had enough time to conduct a floor test. Pro tem chairman was also appointed, and thereafter a chairman. Still no positive action. Instead, they've laid down the budget.
But his point was that it was after
Yes.
30 days had lapsed.
Yes.
That's why he had asked for another date to be fixed.
Now, my lords, on that point, it is not that something, this is happening because adequate communications were not there. If your lordships has the counter affidavit of respondent number 4, LADC secretary. At para 4, my lords.
Dated
This is dated. My lords, it was filed in June, in the month of June.
23rd June is
This is
respondent number 4.
respondent number 4, secretary
Yes,
live,
yes.
LADC, my lords. If your lordships has para 4, this answers this question, my lords. That the contents of para 18 and 19 of the writ petition is admitted, the answering respondent is bound to act on the direction given by the chairman of LADC in issuing summons for sitting the sessions of the district council. It is also submitted that the LADC, as such, including the chairman, were duly informed and aware of the Honorable Governor's direction as contained in letter dated 7th February 25, till the time the respondent number 5 had staked claim before the Honorable Governor but failed to call for a floor test. This is very relevant, my lords. It is not that adequate communications were not there. In fact, the AG had referred to his own counter showing that letter of 22nd April, my lords. That is one point, and my lords, my only second limited point would be, the answer would be in this judgment of Subhash Desai, my lords. This is, the citation is. This was referred to by the Honorable Governor, AG, respected AG, my lords. This is This is 2024, Volume 2, SEC, page 719. Your lordships, in para 186 is.
Let them find it first.
Yes.
I think we should have another screen here so that you know what's
Yes.
going on out here. Yes, para?
186, my lords. Your lordships has it?
Wait, this is searching. Yes.
Yes, my lords. Para 186 reads, my lords. I may read. My lords, the governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which, I'm sorry, this is another, to avert a no confidence motion. The incumbent government may not advise the governor to convene a session of the assembly. Your lordships has
So, yes.
which is happening, when the writ petitioner was in the helm, my lords, this has happened. This was what happened. They had called for the emergency meeting, but failed to call for the floor test. To avert a no confidence motion, the incumbent government may not advise the governor to convene a session of the assembly, and the speaker may adjourn the sitting of the house to prevent voting for granting leave to move a motion of no confidence. If the speaker and governor attempt to circumvent a no confidence motion, the governor would be justified in exercising the power under Article 174 without the aid and advice of the Council of Ministers. In this case, in Subhash Desai, my lords, was a case of no confidence motion. While in our case, your lordships, the floor test has been called. But here, my lords, they have also tried to circumvent. That is why the governor has been said to have given the directions correctly constitutional, my lords. Lastly, my lords, I come back to that judgment in Shivraj Singh. I'm sorry for going here and there, my lords, but just one very relevant paragraph.
This is 2020, 17 SCP.
Yes.
It's still somewhere here on the screen. The previous one.
Yes, my lords.
Wait, I'm getting my court master. Para?
Out here, my lords, your lordships may have para. This is yes, my lords, para 73. Para 73. I'll read, my lords.
Will let him be ready. This is the wrong judgment. This is 2020.
2020. Volume 17.
17, page 1.
But this para 73 start with?
In a situation.
Yes.
In a situation where the House has been summoned following the aid and advice of the Council of Ministers, the position would be more nuanced in the sense that the remedy of a no confidence motion would be available to any segment of the legislature seeking to espouse the view that the government has ceased to command the confidence of the House. In exercising the constitutional authority to demand a trust vote, the governor must do so with circumspection in a manner that ensures that the authority of the House to determine the existence or loss of confidence in the government is not disqualification. However, 14th March 2020, the resignation of 6 members who were ministers of the incumbent government were accepted by the Speaker, acting in exercise of the constitutional authority under the proviso to Article so-and-so, 193B. The Chief Minister
Now
adverting...
you're reading from where?
My lords, the same paragraph, I believe.
Is that
Missing anymore.
absent?
I see. My lords, your lordships may give me a moment. It seems... Oh, 73.
You were reading okay in the beginning, then somewhere in between you lost and read from
Yes.
somewhere else.
My lord, let him be prepared and make submissions.
I'm
and
sorry,
I
I'm
want
sorry,
to
my lords.
counter the.
I am.
Yes, he has been here, he should get ready with his submission.
No, my lords, the publication is the problem. But nonetheless, my lords, I think the point has been already clarified
Yes,
by
it
my
is
learned
clarified.
senior. If my friend won't thing like normal. So, my lords, the floor test should be directed, my lords, ultimately. That is what.
That is what I've been seeking for, Your Lordship, and I'd like to place one more judgment, that is 2017 3SCC, page 758, para 5,
2000.
3SCC. Chandrakant Kavlekar versus Union of India.
Page
Page,
3SCC
page 758.
758. Okay.
Starting from para 5,
Para 5.
yes.
Yes.
It's a short judgment. During the course of hearing, we were satisfied that the instant, sensitive, and contentious issue raised on behalf of the petitioner can be resolved by a simple direction, requiring the holding of a floor test at the earliest. Holding of the floor test would remove all possible ambiguities and would result in giving the democratic process the required credibility. Para 6, we therefore hereby direct that all the prerequisites, formalities for holding a floor test, including the formalities required to be completed by election commission, be completed by so and so. We request the governor of the state of Goa to ensure that the floor test is held on 16/3/2017, and the only agenda for the day would be holding of a floor test to determine whether the chief minister administered the oath of office has support of the majority. The floor test shall be held on 16/3/2017 as early as possible, but surely during the course of the same day. That was direction made in that case. A similar direction to have a floor test on a specified date may also be made by this honorable court, observing all caudal formalities. That's it. Up next.
Yes.
Allow me, my lord. My lord, if we hear all through their submission, they have never addressed that CCB rules 2010. So they just rely upon that the state assembly, not that the sixth schedule, not autonomous district at all. So I am inconsistent with their also submission also, all through their argument and the citation. What they wanted is that to have a floor test. If you go through all the judgment cited by them, the fact of the case, if you read it, so it is true that the court direct them to have floor test, but not in the all those respect. They have never bypassed for floor test of the actual government, not by the second government, opposing government. In all their respect, what it was passed by the floor test to be conducted is by to test of the first government, not the second government. In our case, in this autonomous
What's the second government?
in
Protest is protest.
See, Lordship, I'll just come one by one, very Bomaya, because the council, the senior council, so did not highlight the true fact of the case, because he relied that para is that submission. Submission is not binding at all. Para, he submitted that para 393. This is submission. The very short fact of Bomaya case is that in Karnataka, the Janata Party, they lost majority. That CMN was Bomaya. Bomaya, he was not given a time to prove his majority. He was appointed as chief minister. It come up till Supreme Court. Because what is the decision is that governor proclaim president's rule. What is the decisions of the Supreme Court is that governor cannot proclaim a president's rule without laid before the two houses of the parliament. It was set aside. It is not that Bomaya refused to conduct majority test at all. What he read is that the report of the governor, he read para 392. Here it is very clear. In this connection, my lord, please kindly see that just 393 that my learned senior counsel rely upon. He submitted that chief minister refused to conduct floor test. He hotly rely upon this fact. 390. May I kindly read? S.R. Bomaya.
Yes.
Para 390, he read. He relied upon this one.
This is where did I...
In this connection, it would be appropriate to notice unanimous report of the Committee of Governors appointed by the Presidents of India, the 5 governors unanimously recommended that the test of confidence in the ministry should be normally left to the vote in the assembly. The governor is satisfied by whatever the process or means that the ministry no longer enjoy majority support. He should ask the chief minister to face assembly and prove his majority within the shortest possible time. If the chief minister shirks this primary responsibility and fails to comply, the governor would be in duty bound to initiate steps to form alternative ministry. A chief minister refusal to test his strength on the floor of the assembly can well be interpreted as prima facie proof of his no longer enjoying confidence of the legislature. If then alternative ministry can be formed, which in the governor view is able to command a majority, to be formed in which the governor view is able to assembly. This is one view. On the other hand, if such ministry is possible, the governor will be left with no alternative but to make a report to the president under 356. This is important. There are two review. That is the report. What my senior counsel is the report of the 5 governors. Then second option was go ahead. They complied with second option. President's rule was proclaimed in Bomaya case. Then that without consulting the councils of ministers, without laying before the House of the Parliament, Supreme Court set aside everything. So this is the thing. If that he also relied upon in that Shivraj case, they relied upon, actually, in fact, Bomaya case is my case. I also had given for this reference. In Shivraj case, here, Bomaya case was clearly highlighted very shortly in page number 9.
What, 2017?
Yes. Shivraj Singh Chauhan, 2020, volume 17, SCC, page number 1. Here, very nicely, S.R. Bomaya was highlighted.
Para?
My lord, actually, here at page number 9, page number 9, Parathi. Why I would like to stress is this, because that they rely upon against Shivraj's case. Shivraj also in my favor. Thus, the law, may I kindly read?
Yes.
Are you there? Thus, the law is laid down in S.R. Bomaya, 1994.
Reading para?
3. 1, 2, 3.
Para 3.
My lord, actually, it is in the headline, page number 9.
We are not on the same list, no? That's why.
My lord, I'll note it down. This is very, very short, 3 para only. SCC, I am relying upon SCC publication. My lord, I'll hand over the SCC copy. So this is the thing. Thus, the law laid down in S.R. Bomaya, 1994, volume 3, SCC 1, on the issue of determination whether incumbent government continues to enjoy the confidence of the House and the role of the governor in this regard is as follows. 1. Whether or not the councils of ministers has lost the confidence of the House must be determined only on the floor test and not by governor conducting independent verification. Because in this case, governor conduct his own verification and he cancelled my appointment. Number 2, where the governor has reason to believe that incumbent government does not possess the support of majority in legislative assembly, the correct course of action would be for the governor to call upon the chief minister to face the assembly and to establish majority of incumbent government within the shortest possible time. That time we were incumbent government. When
No, you're in para
9, page number 9.
It's a head note.
Head notes, in
Relying
the
upon
head
the head
note,
note.
page number 9.
It is under para 65.
Head note, page number 9, para 65. Are you there, Lordship? 65?
Not there.
You're there?
How does it start?
Okay. Para 65. In analyzing observation made by
It's not
9.
to be- Are you on the same judgment? This is which?
SCC. SCC.
Number what? SCC what?
2020, volume 17.
Ah,
SCC
one.
page number 1. Chief Raj Singh.
Lordship, the case of the petitioner and the case of the respondent fall on the same line. Now, we can have a floor
No, my
test.
lord,
We can have a floor test on the same day.
no. They
If
want,
he's objecting to the floor
no,
test,
they want to,
he has been given all the opportunities. He has not been able to
no, my lord,
prove
this
his
judgment is that,
majority.
what I would like to stress,
Not, see that's this page 819. Go up, reduce the pages. 58, this is page 56. We are trying to find where you're reading. Come on, go up. See, can you see the page number? I think we still need a little bit of training if we're going to go like this. Are we on this? Is the judgment correct? The one which you had looked at previously. Is it correct, the citation? Are we on the correct page?
Lordship, it may not be a good precedent to have a floor crossing.
Anyways, you go ahead. You give me the para numbers. Just come to the first page. Let me see if it's a correct judgment we're looking at.
2020, volume 17, SCC 1.
Yes.
It is their judgment. It is not my judgment. I'm countering their judgment.
Same, whichever party gives the same judgment, it's okay.
He was relying upon the head note. I'm just indicating
No, it
the
is
actual
there.
paragraph. That's all.
No, the thing is that Pujo Mwana is,
So you're reading from which? From
no,
the head note?
they're same. No, Pujo Mwana is opening another judgment. That is,
Okay.
you just please open 2020, volume
he's
17.
Opened, he's opened the correct judgment. Now you're reading from para what?
Para, it starts from 65.
Para 65.
What I submitted is that their judgment is in our favor.
Okay.
65. Because they also cited Bomaya case. Here, an analysis of Bomaya case is made. May I read in analysis?
Yes.
The observation made by 9 judges bench in S.R. Bomaya, it is pertinent to remember that the governor in that case did not call for a floor test. Rather, the governor of Karnataka sent a report to the president based on which a proclamation was issued under 356. Observation in S.R. Bomaya can be relied on determining whether the governor possessed the power to call for a floor test. Discerning subsequent questions of when the exercise of such power is appropriate is a distinct issue. On perusal of the above observation in S.R. Bomaya, it is evident that 1. 65.1. Whether or not councils of minister has lost the confidence of the House must be determined on the floor test of the House, not by the governor conducting independent verification. In this case, the governor conduct his own verification. 65.2. Where the governor has reason to believe that incumbent does not possess support of the majority in the Legislative Assembly, the correct course of action would be for the governor to call upon the chief minister to face the assembly to establish majority incumbent government within the shortest possible time. Actually, what they pray is that they want to conduct floor test. The respondent number 5 wants to conduct floor test. We are the one who has to conduct floor test. Right from the beginning, we are the one who first submitted it. We have majority. We submitted on 30th. Here also incumbent.
So floor test, the members will be the same, whoever conducts.
But my lord, it should
If
be,
you conduct or the other one person
their appointment
conducts.
should be cancelled because that appointment of that 2nd May 2025 as CM has to cancel. Without cancellation, that means that the bypassing,
Okay, but as of now, what is the position?
because now they are CEM.
Now
Because he
they're
has to
sitting as
conduct floor
CM.
test. We have to conduct floor test first.
Whoever conducts, supposing you get the majority, you'll become CM anyways.
Yes.
Because
As
we-
simple as that. As simple
No,
as
the
that.
first one should prevail.
He
Here,
refused to
incumbent.
have a floor test.
No, we
while
never
he was
refused.
given the opportunity.
See, let the floor test be there. Whoever is a CM at the moment, okay, it'll be just for a few days, then it will be confirmed.
My lord, as
Who's
part,
losing
no,
out?
as part the law, as per the judgment,
Uh,
on all through the judgment they read, it is all the first, the government which was tested. Because our government was being tested. And also here in this judgment, incumbent government has to face the floor test. They are not the incumbent government at all.
My lords,
Okay,
the
that
learned
is
counsel
their
is
point.
Yes,
misinterpreting the
here it is very
judgments.
clear.
Or
My
else
lord,
he would have cited it if it were in
665.3.
his favor.
My lord, let me complete this one, 6 point. They already missed the bus, 65.3, an exception to the invariable rule of testing whether in the government has the assembly confidence on the floor of the house is envisaged only in extraordinary situation where because of existence of all pervasive violence or a free vote is not possible in the house. As a matter of, this is like, what is Srivasing and Bomaya case is that the government, Janata government, because the next government is Congress government, because they are the Janata government has to face the floor test. That the incumbent government has to face the floor test. And they relied upon Chief Judge case, also Chief Judge case, 2020, same principle. And then we have to face the floor test. They keep arguing that they refuse to conduct the floor test. The petitioner refused to conduct the floor test. It is one of their members. Now they have 3 members, they say, V. Zamhuaka, and that the one deputy chairman is their side. Because of them, we could not conduct floor test. It is very clear in that their letter.
Okay, because they had this thing.
Yeah, they
had
defected.
resigned.
Yeah, they defected
They
from
resigned.
our side, and they came to their side. Because of them, we could not conduct the floor test. That's why we have to conduct the floor test.
Yes, but someone was appointed in between it. isn't it?
Yeah, that's why the appointment part they have never addressed all through their argument.
Someone was a bottom, a chairman?
Bottom chairman was appointed, my lord.
was
My lord,
appointed.
actually,
And that chairman could have exercised all the powers of a normal chairman.
my lord, one more thing is that I would like to counter. They again refer 2019 this judgment.
This which judgment, 2019?
2019 volume 10
10?
SCC
Yes,
809.
yes. What's
So-
about that?
Anil Kumar case they refer.
Uh,
This one.
Yes.
And this case also, if you see the fact of the case, because they just make submission without reading the fact of the case. Even
So
in this,
the facts are different.
they're
that's it.
entirely different. It is not in the strict schedule
Not
also.
applicable.
It is not in the strict schedule also because it's slightly different strict schedule and the normal assembly. But still the power of the governor is being highlighted. But here, because in that normal assembly, it is very clear. They have election, majority, they go to governor, automatically the incumbent government lost. But in light autonomous, in strict schedule, it is different. There is a conduct rule, CCB rule, even Chakma also, Mara also, they have it. It was protected by their own conduct rules, CCB rules. It was very clearly, as you stated then, 83, 24, again 50, 51. But in their case, which they relied upon, it is not just the case because there is no rules at all. But we have the rules. We have to respect our rule. We have to abide by the rule. Because as I submitted that if there is something has to be done, it has to be done in that particular manner. I have relied upon 3 judgments. So they never address CCB rules 2010. So in this 2019, Anil Kumar case also, the thing is that they lost the majority and the governor directed them to have floor test, the incumbent government. It is not the case that the former chief minister was terminated and appoint another chief minister. Then after appointment of another chief minister, they never direct
They
for a floor
cancelled the
test.
appointment.
Yeah, that is, because all their judgment, they relied is that case only. Because we never object the floor test. In fact, we want to have floor test. On 18, when their side, chairman and deputy chairman submitted their resignation, because of them, I could not conduct floor test. And the next day itself, I submitted that to the governor, please appoint potent vice chairman. I want to conduct floor test. In the meantime, because of that turbulence, one member defected, they came to them. And now they think that we have majority. We also proclaim that we have majority. And all their judgments are in our favor. Because
So
they
floor
never... And one
Protest
thing,
is the solution.
a solution. But
But
floor
who-
test
yes.
to be conducted by the incumbent government. It is us, the petitioner.
Okay, fine.
And one thing is that all their judgments, yes, I submitted. That's
Okay, not applicable in
yes,
the present
because
case.
Subhas also they
What
replied.
Subhas? 19?
Yes,
What?
Subhas is a very well-known case because we know if you read
Which
live
one?
law,
Which
Ben
one?
Simba,
Which
Subhas
judgment?
Desai, 2025,
2025.
2024, volume
At
2,
least let the learned counsel give correct
No,
citations.
please.
This is very wrong.
2024,
24, man.
volume 2, SCC 714. My lord, this is who is original Shiv Sena case. Very 719. In this case, if we all aware that in Maharashtra government, they are, they want to mean we are original Shiv Sen party. It is a fight between themselves. It is not at all relevant.
So it's not relevant in
Yeah,
this
it's all.
case.
Who is the original Shiv Sen? That is very clear.
Okay, fine. Then next.
Yeah, and my lord, that the thing that the judgment which has to be relied is that my case is that Milai case. It was decided by 5 judges bench of the Supreme Court in respect of discretionary power of the governor. We say that after 30 days left, there is no law, the law is not silent. That time, the governor may able to exercise his discretionary power, or in case this kind of that difficulty arise, he has to, because 163 is very clear, and the law is very clear in Milai case. It is mandatory also to seek advice of the councils of ministers. As I have also submitted one letter. In this case, in Chakma case, the government sought aid and advice of the councils of ministers.
So all those you have mentioned, isn't
I have
it?
mentioned.
No.
And my lord, exactly
In
similar
rebuttal
case
to
I
what you are
have.
saying, no.
I have this one, because this one I tried to get from SCC, but I have Supreme Today AI. Supreme Today AI, but it is reported in 1976 AR, Gauhati, page number 20. My lord, may I give you the hard copy?
Yes, yes.
No, actually I get it from Supreme Today AI. Because my learned senior counsels rely that the Sikh schedule 16.2 and 22B and 20B. Here it is the solution. It is passed by Guwahati. Again, this is in respect of Sikh schedule, Autonomous District Council. The head note itself is that the governor function under Sikh schedule except in those,
Para.
my lord, in those matters where he is required to, the very
Okay,
first
the
line.
first page. Huh?
Yes. Governor function under 6th schedule except in those matters where he is required to act in his discretion must be exercised, they use, with the aid and advice of his councils of minister. And again,
Exception is there. We are under
my lord,
exception.
but exception if specific power is given to governor, he can enjoy.
See, where? You're just reading the headlines.
My lord,
This
para
little
13,
headline, huh?
para 13. It starts from
Read
para
the
13.
contents of the judgment, huh?
But this whole issue of this case is that he must, it is written. When he
See,
exercises,
because
in the schedule,
headlines is done by the clerk,
yeah,
the legal clerk. What they find out from the judgment, what they feel is it's done by the
yes,
court
yes,
clerk.
my lord, but that,
So we have to look at the judgments.
yes,
huh?
para 13, it starts from, in the schedule, in this, that is means Sikh schedule, We find that so far as autonomous district and regions are concerned, governor is required to act in his discretion expressly or by necessary implication only as respect para 9.2 and para 14.2. Thus, even if we assume that the power exercisable by the governor under 6th schedule with regard to autonomous districts and regions are not in discharge of executive functions of the state, but of the executive functions of the governor, such functions subject to exceptions stated above must, in view of Article 163(1) of the Constitution, be exercised with the aid and advice of his councils of ministers. A question here arises for consideration. It is whether the power are conferred on a governor in his personal capacity without reference to his council, that means councils of ministers. If the expression governor is used in any article or provisions in the Constitution, in our opinion, if the governor has to act in his personal capacity, whenever in any article of the Constitution, expression governor occurs, it will upset the whole constitutional structures envisages at the time when the Constitution was passed, will make the governor a kind of a dictator to read every article of the Constitution in which expression governor occurs, and conferring power upon the governor in his personal capacity without reference to the community would be constitutionally incorrect. Therefore, that he must consult the aid and advice of the Council of Ministers. This is the law. In our case, nothing is mentioned because it was silent. If it is silent, and he has to exercise his discretion. But my reply is that, my lord, the law is not silent when 30 days is lapsed. In view of that 24 and 83, because if you see 24, the headline itself is that it is very clear, removal of executive member, and 83 is very clear how it has to be done. Because in case, if the petitioner, the petitioner is not supposed to conduct the floor test, is not supposed to commence. It has to come from them, which they resign, because it has to come from the chairman. The chairman is the one, has to preside over, because the law is very clear.
Not you.
Yeah, not me at all.
Yes.
Because of that, they request pro tem chairman. Only after they appoint chairman.
So now there's a chairman appointed?
Now,
There's a chairman?
no,
After the pro tem chairman was appointed, my lords, there was an
Someone
election
is
for the
no,
appointed.
it was there. Pro tem chairman was
After,
Biak-
right
Lal Biak
now,
Sangi.
at
It was there.
present, there is a proper chairman appointed?
Yeah, this was there. Lal Biak Sangi, the first and only one in
Pro tem
Lai Autonomous
chairman.
District Council.
Okay, is now the chairman?
Yes.
Okay.
And my lord, then my point is that then 83 comes if 30 days lapse, because they cannot bypass their CCB rules, conduct rules. The governor cannot, it is not his personal satisfaction, it is written. 83 rules, one of the member, any of them, can file notice of motion. My lord, that is very crucial, and this is the deciding factor. 83. Again, if you see again,
I think we have read this.
my lord, actually, again, because they have never mentioned, they have never.
They did
they-
mention, so it's good enough for
Lordship,
you, it's better for you.
But this is, the thing is that, my lord,
No confidence
because,
motion.
my lord, they claim that you lost majority. The fact that to prove that we did not lose majority is that even that the budget was passed, because budget was passed in April 22nd, in our favor. Because if we lost majority, how can that the members supported me? Not only after that the governor, try to bypass the mandate of the people, and some member defected, they came to them. And we have to face the floor test. And I admitted they want us to floor test, but not them. Because if floor test is conducted, that means the court accepted that the unconstitutionality in action done by the governor. Because in all respect, it must go. Notification 2.5 and 7.5 must go. And go back, then we have to conduct, that floor test has to be conducted as per their submission.
Okay. Yes.
Lordship, short reply. This motion of no confidence is after the executive committee functioned properly for the purpose of dismissal or removal of that particular government, this provision is inserted under section 80, under Rule 83.
83, huh?
Rule 83 has to be applied not in the beginning, but after the government is installed.
formed, huh?
In respect of the petitioner, he has not been properly installed.
No, government was
The
already
question
there.
of removal, the question of no confidence under Rule 83 cannot be applied in his case.
No. The petitioner already enjoy CM.
So
He was-
anyway,
Yeah, they enjoy already. My lord, Rule 50 and 51 is very clear. The proceeding, the budget cannot be declared invalid. Section
That
50 and 51.
budget was also passed without
Yeah,
authority.
budget only because the
So I got your submissions anyway. I've heard you're not going to agree, so obviously your point is that
Yes, you
the
are-
government should be there. You're saying you're already the government, isn't it?
because all their judgments in my favor.
Yes,
If
anyways.
you look carefully.
Lordship, in view of the urgency of the matter, if the matter can be disposed
Then
of,
let's see, I have
the
other
earliest.
previous CAVs pending, but let's see.
I
whether this can be given
understand that
priority.
Lordship is having number of CAVs,
Pending.
but in view of the urgency, because it's not the parties who are suffering, it is the people behind those parties, they're suffering.
Anyways.
So in view of that, Lordship, if
We'll have a look.
matter can be
We'll have a
given
look.
priority.
Yes. Heard Mr. J.C. Williams, learned counsel for the petitioner. Also heard Mr. B. Deep, learned Advocate General for the state respondent.
Actually, respondent number 3 councils, 4 councils is there. At least he adopted their submission, I think.
You are for whom?
Respondent number 4.
You adopting everything? Yes. Okay. Then Mr. C. Lalram Zawa, learned senior counsel for the respondent number 5. Assisted by Mr. Jordan Romintala, learned counsel, and Mr. Arnold Munsiama, learned counsel for respondent number 4. Hearing concluded. Matter reserved for judgment.